Good afternoon, and welcome to the Appellate Division First Department. Most of you know how we do things here. I'm going to call the calendar and ask that you give me the time that you need, not the time that you want, okay? We have 5 hours of requested argument time, and I can assure you the people at the end of the calendar don't want to be here for 5 hours. So please know that the bench is familiar with your case, the record, the briefs, oftentimes more than you wish we were. So please ask for what you want so I don't have to cut you off and cut off your time. Also know that the clock is for you, not for my colleagues. So if you are brilliant in your arguments and have my colleagues wanting to ask more questions, I let them continue, okay? So, People versus Kelvin Buzet. Okay. 5 and 1 and 5, good start. Watson Photography versus Kartheiser. Sorry if I messed up the last name. Okay.
10 minutes for respondent.
5 and 1 and 5. T. Yakov versus Tracy S. is submitted. Pursuit Credit versus Crunch Cash, LLC.
For appellant's judge, 4 and 4.
Okay.
For respondent, 10 minutes if needed.
Okay, let's do 4 and 6. Manhattan Christie versus 215 Christie Investors.
For appellant, 7 and 3, Your Honor.
Okay.
For respondent, Your Honor, 8. And for respondent, 0, Kelvin, and 1.
5 and 1, 5 and 5. Mish versus Good Samaritan.
Good afternoon. For the plaintiff appellant, 7 minutes and 2. Respondent, Good Sam, 5 minutes. Respondent, Dr. O'Hara, assistance.
Respondent, Dr. Blau.
Okay. Give me the times again.
Plaintiff appellant, 7 and 2 in rebuttal.
Okay, 6 and 2, go.
Good Sam, respondent, 5.
All right, 5.
Dr. O'Hara, assistance.
5. Next,
Reed and Blau, 3 minutes.
3. Zeng versus Centers Urgent Care.
Plaintiff appellant, and I guess respondent for the cost of 2 and 3.
Okay,
For respondent and cross appellant, 5 and 2.
all right, 2 and 3 and 3 and 2. People versus Suchin.
5 and 1 for the appellant.
Okay,
For respondent, 3 minutes, please, Your Honor.
okay, 5 and 1 and 3. Citibank v. OWS Administration.
7 and 2 for appellant's, Your Honor.
Okay,
5 minutes for the commissioner respondent. 5 minutes for respondent.
all right, 6 and 1, 5 and 5. M. Trina versus Brian P. Submitted. Trump versus Trump.
10 and 2, Your Honor, for appellant Mary Trump.
Okay.
10 for respondent.
6 and 1 and 6. Grand Sard versus New York City Board of Elections.
5 for respondent.
5 and 1 and 5. GSB Gold versus Google.
For appellant, 13 and 2, please.
Okay. 5 and 1 and 5. Vicurgo Villar versus Samoa is submitted. Rosenberg versus Wilson is submitted. First case on the calendar, People versus Kelvin Buzet.
Oh, aren't we taking, we're not doing management first?
I'm sorry,
We're not doing, okay.
Good afternoon, Your Honors. David Bertan for Mr. Busquith. Your Honors, it's actually pretty simple in this case. The defendant expects a fair trial with sufficient evidence, tried for his own conduct, and not have evidence that isn't properly authenticated or have a proper foundation. Looking at first the reasonable doubt issue, Your Honor, you have witnesses who did not identify the defendant in court. Mr. Smith didn't recognize him in court. Mr. Prasad did not make an identification. You have
All of those facts were before the jury, were they not?
Yes, they were, Your Honor.
So why, you would have to meet a very, very, very high burden for
Very
us
high
to
standard.
overturn a jury determination. So tell me why we would do that here.
Your Honor, in this case, you don't just have problems with the identification. You have problems with the way evidence was secured. You have a knife that nobody seems to know how it ended up being voucher. You have a pistol with a magazine. No one seems to know how that ended up being voucher. You have video evidence that has no foundational support for it.
But you know, you say the magazine, the gun is recovered from below the window of the defendant's grandmother in the backyard, in the courtyard. Is that correct?
Yes.
And eventually it's established, is it not, that that is the weapon from which the shots which injured the victims was fired?
Yes. Yes. However,
So
I'm sorry.
why does the vouchering problem lead to a reversal?
Well, in this case, Your Honor, it's not just the vouchering of the gun. It is the vouchering of the knife that was found in the mailbox. It is the fact that,
And in whose mailbox is it found?
again, a relative named Busquith, Your Honor. All I can say about that,
So
Your-
wouldn't these problems go to the weight of the evidence rather than admissibility? And again, how does it get you to a reversal?
well, Your Honor, it does go to the weight, and this court has the power to look at that evidence and determine, based on all the factors in this case, including the improper foundations, the lack of ID, that the evidence was not sufficient. Couple that with the fact that he was,
This is a case in which you have a video of the shooting, you know?
yes, but there's no one who can identify the defendant on the video, and that video itself was improperly admitted.
Didn't we, several of us having been on the case a couple of years ago, find that that video, that same surveillance video footage that was recorded was properly admitted?
That was on the sister's separate appeal, Your Honor, with conceitedly, court did deny that issue. But in this case, we have different sets of objections. We have different issues for the foundation. And in looking at the single video that's really at issue here, which is the video from, I believe it's 1769, you have the officer who testifies he simply copied from the computer without looking at it. And then you have the superintendent who simply set up the video.
What difference would that make?
There's no one who can look at the video on the computer and the video on the DVD to say that they are the same thing. And that's the foundation issue in this case, Your Honor. And that's the reason why I believe in this case that video should not have been admitted at this trial.
Counsel, as to Prasad, Smith, and Lokai, didn't they know the defendant way beforehand, before this incident happened?
Yes, they did, but Mr. Smith didn't recognize him in court, wouldn't identify him
Didn't he
in court.
recognize him because he looked different from when he was first arrested?
Your Honor, I would submit to you that a pair of glasses and a few pounds, as I noted in my brief, do not make that much of a difference.
Depends on how many pounds.
Yes. I'm sorry.
He did recognize him in the arrest photo, though. Didn't he identify him there?
Yes, they did, Your Honor. If the court has no further questions, I think I'm going to take a seat. On the whole, it is nice to be here.
Maria Wager for the Bronx District Attorney. Good afternoon. There is no question that defendant shot the complainants in this case. I mean, I know the term overwhelming evidence is thrown around a lot, but in this case, it truly is overwhelming. There were 3 complainants. They all knew the defendant very well. They all grew up on that block. 2 of them had moved away but returned to the block a few times a week to visit family.
So should we be concerned at all about the fact they couldn't identify, that one of them couldn't identify him at trial?
Even with the extra pounds.
It was more than a few extra pounds. There was also facial hair and glasses. But I want to point out that all 3 complainants did identify the defendant. One, and I believe it was, Smith, when asked if he recognized defendant in court, said no. The prosecutor reported to the court the next day, and walking Smith back to the office, he commented to her friend, wow, he looks so different. So we know, with the nervousness, fear, whatever, he hesitated and didn't identify him, but he did identify him from his arrest photo. He also identified him by name several times in his testimony before he was even asked to make an in-court identification, and also knew where he lived. And then you have 2 other complainants who did make an in-court ID. So you have 3 altogether, but that would be enough. But here you also have 3 sets of video, cell phone video, surveillance video from 2 different buildings, and as Your Honor pointed out, you have the weapon that was matched to all the ballistics that was strewn down Eastburn Avenue, all comes back to that gun, magazine in the courtyard, right outside defendant's grandmother's first floor window, where we know he fled after the shooting. So it really, truly is overwhelming, and the jury's verdict should not be disturbed. As I just want to comment briefly, do I have time?
Yes.
On the problems, the alleged problems with vouchering of evidence, all of that is just a distraction. This was a large crime scene that went for about 1.5 blocks, many buildings, 2 victims shot, 1 stabbed, evidence collection, detectives all over the place. Officers were assigned limited duties: watch this piece of evidence until it's collected, voucher this, process the arrest. The fact that they lacked memory about details is irrelevant. Defense does not challenge the admission of any of that evidence except for the video, which, Your Honor, is correct. You already found it was admissible. The other exhibit had the even stronger foundation, and nobody ever objected to it. Throughout the whole trial, there was no objection.
Thank you.
Thank you very much.
And just for everyone's edification, when you have 2 minutes left, the white light will go on. When you're out of time, the red light goes on. You're foregoing your time? Thank you. All right. Watson Photography versus Kartheiser. Thank you. You may proceed when you're ready.
May it please the court. My name is Matthew Cuomo. I represent the appellants Caroline Walter Mead and Robert Kartheiser. This is a water leak case in an apartment here in Manhattan. And the Supreme Court made an initial determination, which was correct.
What actually failed here? Was it a plastic coupling, or is it a rubber inside the coupling?
If you've ever been in Home Depot or Lowe's or something like that, you see these flexible water supply lines. So it was the plastic nut that connects the flexible stainless steel water line to the bottom of the toilet tank. And the expert.
Is this something that your clients were able to visually see this nut?
Yes, they could see it. You'd have to bend down and look at the bottom of the toilet tank. But if there had been any leaking before this occurrence,
there hadn't been any, this nut, whether it's the rubber or the plastic coupling, and do we know for sure which of the 2 it is? Because I know one of the experts says there's something on the rub, but the rubber is inside the plastic, isn't it?
Right. The black rubber gasket inside the fitting is not what failed. It's the white.
It's the plastic just split open.
Just split open.
And there was no leak before it split open.
There was no leak before it split open. The homeowners had owned the home for 4 years before this particular fixture was in place when they bought the home. There were no product tags.
Weren't there problems after they bought it, prior to this flooding with water and leaking?
Not in their apartment, Your Honor. Absolutely.
But above them?
Above them.
Wasn't that 4 years before? which is dealt with in the contract of sale, that in 2011, there's a representation that there had been a leak in apartment 3A,
Right.
which leaked into 2A,
Your Honor,
but it had been repaired.
there was a prior leak from an apartment above my client's apartment before they purchased it. There were several leaks from various different apartments into their apartment after they purchased the apartment. But as the Supreme Court properly found, and as the Federal District Court properly found in the related case, you can't take other leaks in the building and turn them into notice that there might be a problem in your apartment.
What do we do with your client's statement during deposition when he testified water issues are endemic in old loft buildings converted into condominiums, and experiencing leaks from other units was part of living in these lofts? So that statement seems to indicate that he has an awareness that the building may have issues with its water leaking, et cetera. So my question is, after having experienced leaks from other units, did he affirmatively take any steps to ensure that his unit would not become one of those units that leaked?
Well, Your Honor, that then begs the question of what steps are you to take? All of the other leaks from other parts of the building were from various different instrumentalities. So you have, it may have been this type of pipe or that type of air conditioning fixture.
Again, he testified water issues are endemic. So look, all I'm saying is, he certainly didn't create the situation. He bought the apartment. But if you have various apartments around you, spring leaks all of a sudden, wouldn't that cause you to check out your own to make sure yours is not a problem?
Not as a matter of law, Your Honor, and this court has spoken to that in the Mitchell case, where this court, not this bench obviously, but this court years ago said, in order for there to be constructive notice, it has to be notice of the instrumentality in that place. And there was never any problem in my client's apartment before this incident occurred. This incident occurred, the Supreme Court was correct on that level, that there was no creation, no actual notice, no constructive notice. What the Supreme Court did wrong is they then added this new duty to create a program of inspections for homeowners.
And is there any case that requires that program of inspection?
Not for homeowners, Your Honor. And more importantly, when we look at the facts in this case, we have the bylaws of the building don't require inspections. The professional staff in the building never suggested inspections. There was an insurance evaluation of the property done about I see my time is up, if I could just...
I'll let you finish your
Is
statement,
there any
please.
case which says that an apartment owner, condo owner, has an obligation as an individual owner to make periodic inspections?
Not that I have found, Your
absent
Honor.
notice of a problem?
Not that I have found.
Counsel, and even if your clients had inspected that particular area every day, would it have given them notice of what was coming?
Not based upon the evidence on this record, Your Honor.
Thank you. You'll have time on rebuttal. You may proceed.
Your Honors, there are several unresolved questions of fact that can only be resolved by the trier of fact. Number
Counsel,
one,
but going back, did you find any cases finding an individual homeowner in a co-op or condo responsible to conduct inspections of plumbing that had given no signs of defect?
not in that exact context, Your Honor, but the case law does not contain the limitations that appellant's counsel is trying to impose on it. What the cases say is
But
that
the
with
cases
respect
you
to...
do cite, are really quite afield from the situation we have at bar, isn't it? I mean, you have Hoffman versus United Methodist Church. Where there's a stair tread which is so worn out that if you look at it, you see that there's reason to make further inspection. Bentley is talking about with the public premises, a pizzeria, where there's a history of leaks from the premises and that some witnesses have observed water in the area of the collapsed ceiling. In Conklin, there's rusty stairs, which if you just look at the stairs, you know that there's a problem. You don't have anything like that in this case, do you?
Well, we don't need to show actual notice based on a history of leaks from the particular instrumentality, Your Honor. For instance, in
What history of leaks in this particular instrumentality?
Right, I'm saying we do not need to show a history of leaks from this specific instrumentality. We can have constructive notice imputed to appellants based on their failure to conduct a series of inspections.
But that goes back to the first question. What case law requires these inspections?
And to answer that question, I'll start with Bentley v. All-Star. In that case, Your Honor, one of the defendants was the building owner. The other defendant was a tenant restaurant on the second floor. And even though it was a tenant and not an owner on the second floor, water leaked into the first floor and caused the ceiling to collapse. And this court held that there is a question of fact as to whether constructive notice could be imputed.
I have to grant you that there is no question that the law has recognized in this case law support for the idea that you need to make inspections. But, as far as I can tell, and that's why I really second Judge Gesma's question, all of those cases deal with apartment buildings, commercial premises, businesses. Obviously, in an apartment building, the idea that the owner has a duty to have some sort of maintenance and inspection of problems makes sense. But I mean, what you're in effect saying here is that every person who owns a condo has to, on a regular basis, call in a plumber to go over any place that there might be a leak that...
A concealed leak.
A concealed leak, yeah, thank you. That there might be a concealed leak. If there's a leak in the wall, how's it to be found?
If I can respond to that, Your Honor, this isn't like Lee and the other cases cited by appellant's counsel where we're talking about dismantling wood or we're talking about breaking down a wall to get to the contents inside. All I'm saying is that in the 4 years in which appellants lived in apartment 2A, they needed to conduct, at the very least, a single inspection.
Based on what? If there is no leak in my apartment, why do I have to hire a plumber to come and check if there might become a leak?
Because the case law states that even if you don't specifically observe that leak, you need to conduct those periodic inspections where there's a part that's capable of deteriorating.
Well, actually, the expert proof on this from Paul Dwyer is that if this had been properly designed, and actually there's a product's liability aspect to this, had this plastic piece been properly supplied, it should never have given way and it should have lasted until that flexible tube was removed.
First of all, that's false. Our expert, Richard Vivenzio, and the other expert, Parkin, testified that you do need to continually inspect and maintain these parts, that they do not exist in a state of perfection until it's time to replace them, and that if a plumber had inspected the part, they would have seen scratches, corrosion, other examples of deterioration.
So you are saying that we should issue a decision that requires condominium and co-op owners to have intermittent inspections of what duration, exactly what, you're not saying, but have an inspection of some sort in order to rule out a maybe failure of a screw, a nut, a hose.
All I'm saying, Your Honor, is that based on the existing case law, and I've cited them in my briefing, I can cite it.
Don't talk. No, there is no existing case law that creates this duty, okay? You want us to create a new duty.
Your Honor.
On the basis of what?
On the basis of the duty to maintain your premises in a reasonable state of care.
And wouldn't you have to have some kind of indicia that something is wrong before a duty is created to search for a problem?
I see that the red light's on. Can I answer that question?
If I asked it, you can answer it.
Okay, great. There is a duty, even without expressly observing the leaks. And what I would point to is the duty to exercise reasonable care in maintaining their property to prevent injury to adjacent property owners. This is a case where they owned Unit 2A. There are clearly adjacent property owners all within the building, including our clients in 1A. So it was their responsibility to maintain their unit in good care. And part of that is to conduct periodic inspections for the two reasons that I mentioned before. It's capable of deterioration. And what capable of deterioration really means is that if you bother to look at it more than a cursory look, it's not the flapper handle, it's not something in the toilet bowl that you can easily see.
Even the experts, even the experts in this case, when they describe a sign, right? The sign was some small discoloration in the nut.
Your Honor, that's not...
It defies logic, counsel. But you've made your argument.
If I can just say one
I have one more
My
question.
colleague has a question.
So you're saying that there's a duty to inspect periodically?
Yes.
So if they'd inspected once in 4 years and didn't find anything, then would they not be liable? Or is the duty you're creating have some frequency attached to it? Because there's nothing, how would we define that? And how would anyone know whether they were meeting their duty?
What I'm arguing, Your Honor, is not that there's a specific time period attached to it. I'm saying that the failure to do it within 4 years, at the very least, there's a
So
question
if
of
they
fact
had
as
done
to
it
whether
in
that
2,
was
it would have been
reasonable.
okay?
I would have
But
argued...
my colleague's question is trying to ascertain
Yes.
what equals
Good enough.
good enough. What is a proper observation of this duty you want us to
And I'll
create?
point to the Parkin report where they have the literature for some of the water supply lines where they note that conduction should be conducted every 6 months, and in one case they say 1 year.
So now we want apartment dwellers to know the ins and outs of how long nuts and screws last in a plumbing context. We're gonna make apartment dwellers experts on this now.
To make sure that innocent people don't have 22,000 gallons of water dumped down on them through no fault of their own, because the 2 lawyers who live above haven't even...
The
had a
fact
single-
that they're lawyers is irrelevant, and I resent you even saying that.
Your Honor,
It has absolutely nothing to do with it. You have pointed to no law that requires that duty. So for you to say that is just over the top, counsel. Thank you. You can have a seat. You have time on rebuttal.
I see my time.
Thank you. Next. Pursuit Credit versus Crunch Cash. Both Justices David Friedman and Justice Ellen Gesmer are recused on this case. Justice Mendez has been vouched in. Should we have a tie, we will follow the appellate division rules in vouching in yet another judge.
I can clear a room.
And it wasn't you. You may continue.
Thank you, Judge. James M. Catterson, Pillsbury, Winthrop, Shaw, Pittman, on behalf of the appellants. This is an extraordinarily unusual case, and not in a good way. It is undisputed on this record that the defendants and defense counsel didn't steal or deceive anything. The information produced was subpoenaed by both sides. The subpoenas were virtually identical. There's no finding in Supreme Court's order about any specific documents that the defendants reviewed. The documents that defense counsel reviewed were documents they had specifically and expressly sought through the subpoena, which again was identical to the respondent's subpoena.
But let me ask you something.
Yes,
So
Judge.
the subpoena went to a non-party who did financial work for the plaintiff and had prepared financial reports for them a couple years earlier, I believe. And when it came through, there was a link that was easily accessible. And once you hit the link, there were different folders that came up, and one of them was legal. And so that should have, opened somebody's thought, ooh, I wonder what this is. Is this the right kind of thing that we should be receiving? Also, the plaintiff's attorney saw this very quickly and said, attorney's eyes only until we take a look a little bit further. And I know in the commercial part, we have rules that talk about clawing back documents that shouldn't have been given. So the concern here is, shouldn't the defendant's lawyer have realized there might be a problem and just said, wait, nobody take a look until we figure this out?
Several points on that, Judge.
Thanks.
First, it's important to remember that the third party, Presniat, I think that's
Yeah,
right,
I don't know how to pronounce
Presniat?
it either.
produced all of the links he was going to send out in response to the subpoena to Respondent's counsel in advance and said, what do you want me to do? It's in the deposition, it's cited in our brief, and they said, produce it all. So do you want to review it? Go ahead, produce it all. There's evidence in the record that they indeed started to review all of those documents and didn't say a word about them. Whether or not there were documents that shouldn't have been produced is really not an issue in this case, because the judge made a finding there was nothing privileged that was disclosed. He accepted Respondent's counsel's representation. The minute he saw legal, he said, I'm not doing it. He also said that Rule 4.4 isn't implicated, and that, of course, is if there's an inadvertent disclosure from another party, you have to say to the lawyer, and look, I think half the lawyers in this room have gotten emails that say reply all inadvertently, and they send it back. That's not this. Both sides subpoenaed the exact same thing. The most important part about this, Judge, is that 92% of that which was produced was ultimately produced in response to those subpoenas by the other side. The remaining 8%, the court acknowledges, we never used, didn't look at, and didn't use. So what I have now is a situation where, based on one Court of Appeals case that has nothing to do with this, and of course a Western District of Virginia case that's been cited one time ever, my client has been sanctioned $150,000 for nothing. There's no finding that there was privilege. In fact, the judge says exactly the opposite. There's no sanction imposed under Part 130 or 202.
Wasn't there a situation that the attorneys let the client take a look at these documents, Mr. Hackman?
The record discloses that at the very moment that the other side sent a hold and said, I want to designate it provisionally, by the way, and they had started looking at them before this. I want to designate it attorney's eyes only. The record is undisputed, and the court says that. There's no proof that the client looked at anything after that. The court specifically says that, and if I could just finish that up. The court scheduled a TRO hearing on this because the claim was that the client was all over this even after that designation, because they had triangulated the IP address and that the Dropbox ledger showed unauthorized access. Of course, when their own expert gets on the stand, Weiss gets on the stand, he was a witness for us. Weiss said, I have no idea what you're talking about. There's no such thing as triangulating IP addresses. And by the way, that unauthorized access in your spreadsheet is not a term Dropbox uses. The last question to that is important, though. The lawyer says, well, were those terms in the ledger on the Dropbox ledger when you looked at it? No, which means somebody added that after the fact. Weiss disproves entirely, and the court credited that nobody looked at it, and the court made a finding that there was no violation of the TRO or the protective order.
Thank you.
Jump at it again on rebuttal. Thank you.
Right.
Thank you, Your Honors. Renee Bea from Slarsky LLC for Respondent and Plaintiff in the underlying action, Pursuit Credit Special Opportunity Fund. This is not about discovery. This is about whether or not a litigant can enter an adversary's live corporate file directory and help themselves to all of their adversary's business files. I would like to address some of the points that my friend made because they are wrong.
I want you to specifically address his statement that this individual that they got the link from contacted your people and asked them whether they could forward what he had and that you said yes. So, well, not you personally. I need you to address that specific issue.
Actually, it was me personally, and frankly, I am astonished at that claim. The documents were produced by Mr. Persignon directly to the law firm of Robbins Kaplan, and it was from the Robbins Kaplan share file that not only my firm first received the production, we all received the production simultaneously, but also Mr. Hackman, the defendant in the underlying case, directly downloaded the documents from Robbins Kaplan, reviewed them, and the evidence does show that Mr. Hackman, and by the way, he admitted it, so we don't need any more than his own word. He says he spent days downloading and reviewing these documents before anybody at his counsel's firm cut him off, and it wasn't until 10 days after that access point that our opposing counsel informed respondents of this access, and even then, only through a letter that point by point in 6 different categories describes the materials and asserts, and I'm paraphrasing, but I think the quote is pretty close to correct, they asserted that they were entitled to use every single document in Pursuit's live corporate directory.
Didn't they think that you should withdraw your case as a result of the documents that they had found in this production? And if you got the production on the same day as the defendants got the production, how long did it take you to write that attorney's eyes only letter?
Allow me to take your question in 2 parts, because it goes in a couple different directions. First of all, I believe your first question was asking if we had received the materials, or maybe I'll take your second question first. How long did it take? The original designation of attorney's eyes only was responding to the fact that Mr. Persignon overproduced way beyond the scope of the original subpoena. And so, although I don't think this is an issue in this appeal, it wasn't reasonable for Pursuit to have anticipated, based strictly on the scope of the subpoena, that those kinds of documents would be in there. And so the provisional attorney's eyes only designation was to allow for the review and designation of confidentiality under the protective order. It was not, at that point, respondents were not aware that there were links that provided access to a live corporate file directory. And let me just add that in reviewing that live corporate file directory, we have representations from the firm of Robbins Kaplan that they only peeked at the legal folder. That's in the record. Counsel admitted that. But again, multiple representations throughout the record where they actually assert that they're entitled to use every single document. But what you do not have in the record is any assurance.
You haven't answered the question.
I'm sorry.
Because it's really important. If you are on the email that has sent your adversary, like the file cabinet of your corporation, it seems to me that is like the house is burning. Nothing else is more important to me at that point than someone from your firm jumping on this and saying, slow down, there's a big mistake, right? So how, again, going back to my colleague's question, how long did it take for your people to realize that the house was burning?
Your Honor, Mr. Persignon did not produce the files that are contained in Pursuit's corporate file directory, which was a live, real-time file directory that the company was actively using. What he produced was a series of emails indiscriminately over the course of his professional relationship with my clients. One of those included a single link. They keep referencing 24. Some of these were just typical digital attachments. That's a different category. There was one link, and that link provided access to Mr. Persignon, who independently had his own password access because he is effectively an outside hired officer of the company.
There was also a confidentiality agreement between
he was under
you
2 confidentiality orders.
In fact, only 3 people had access
Only
to that
3
live
people
link.
had access.
I get it. This
And-
should not have gone
No,
out.
and I'm trying to answer. So it wasn't, so the appellants went into that directory and were rummaging around for 10 days, and it was not until we received a letter from opposing counsel telling us that they had reviewed it and threatening us and insisting that my client dismiss the case, or else that my firm or my client was aware that there was any kind of live link or direct access to a present day directory. And that link, by the way, was from 2019. So what is there today and what is in the corporate files today is different from what was present in those files back in 2019 when that link was originally sent to someone who was otherwise authorized.
So you're saying you did not realize that independently until approximately 10 days later when they sent that letter to you?
We did not realize that independently, and I did go back and investigate. I think this is what Your Honor would like to know. And we ingested the production into a review platform because, again, we were reviewing it to assign confidentiality designations. In that review platform, these did not appear as live links. The review platform processes the information into images, and so they didn't appear that way to us. It was only after we were alerted by the letter and went back to the raw underlying data and had to go back and find.
So that tells me that whoever was looking at this link wasn't tapping on the links. I'm sorry. I don't understand that. I really don't understand how it takes 10 days for your people to have, you got to have them tell you, Bo, by the way, this is in here?
Well, appellant argues that it took him 10 days to look at them, and he had enough time to write that letter, but not enough time to give anyone a call and let them know that these had been found. And I want to emphasize here, the rubric of CPLR 3103 and all of these cases are about inadvertent disclosure. Things happen, mistakes happen, and if there was a mistake that's laid at the feet of my client, it's, having a link that they did not realize, and there's testimony in the record of that. They did not realize that that's the kind of access it would provide, but that's not what this case is about, and that's not what the trial court's order is about. Right. The question is, once you click on that link, are you entitled to go into a litigation adversary's live corporate environment? It's akin to walking into their office, looking around, realizing nobody is looking, and photocopying every single document in that file room and running out the door with it to pen a letter demanding dismissal of the lawsuit. I think the trial court does an excellent job of walking you through why it is that conduct. It is after the link is accessed and everything that the appellants did afterward that really matters. And by the way, defendant Mr. Hackman, we don't have any assurance. There is no assurance from Mr. Hackman that he hasn't reviewed the legal files, and we cannot purge his memory. So even standing here today, there is prejudice to my client based on what happened, and the trial court's order mirrors at least some of the harm and tries to rectify that, which is well within the court's discretion under 3103.
Thank you. I'm going to add a minute to your time. Okay.
394 of the record. Direct answer to your question. My representation to the court was accurate. This is the deposition of Parjnyat by my client, Mr. Bird. It's on page 394 of the record. Question, did they ask you whether they could review the documents before the documents were disclosed to my firm? Answer, yeah. Did you let them do that? Answer, yes. Answer, no. It goes both ways. Okay, so what is it that Mr. Freed's firm asked you to do with the documents prior to your uploading them to a secured server? Answer, just produce them. Just produce them.
But if it was done by mistake, shouldn't that have been something that the defendant's attorney should have considered? Say, well, no, we got this by mistake here, most likely.
That's how it looks now. It does. It does. But Judge, in all fairness to what actually happened here, everyone has to remember that all of the documents that were ultimately used in this case were produced by the respondent in discovery.
What do we do with the ones that weren't and that should not have been?
The court granted a protective order. The court granted a protective order after it was
But the court sanctioned you based upon the legal fees that the plaintiff had to spend to make the motion to get the protective order and the time and money and getting the expert and all that kind of stuff. And the suggestion was that under the rules in the commercial division and whatever, that your client should have known that those documents were not to be used, that there was a clawback provision, and that you should, I mean, I thought that there was some time where the attorney that was handling it said, I was very busy, I didn't get a chance to notify you of this, but he had time to write this very long letter. So I think I thought that's what the judge was looking at, Judge Cohen.
It was hard to tell exactly what the basis for the sanction was. As I started out this afternoon, if I could just finish this, there is no recitation of what section of any law imposed a $150,000 sanction. There is none. He cited one case, Lippin. And of course, I know you all know Lippin. Lippin's the landmark case. And he says the following: the facts of the instant case are less egregious than in Lupin, There was no theft of privileged documents here, and striking of the pleadings has not been suggested. Counsel's attempt to use the documents obtained through an unauthorized search of Pursuit's computer files to obtain litigation advantage. There was no unauthorized search. It was pursuant to the same subpoena they served. The thought, though, that we could be sanctioned for ultimately using only the documents that were produced in response to the same subpoena is incredible. It's even more incredible because this is what the court ended that quote with. And it's very important, Judge. He said, in the court's view, it was, quote, a breach of the orderly disclosure scheme set forth in CPLR Article 31. That is the only allusion to a basis in law for imposing a $150,000 sanction. That wasn't the basis for the imposition of the sanction in Lupin. In fact, it was just the opposite. The basis for the sanction in Lupin was that the Court of Appeals quoted just then Justice Moskowitz's decision in Supreme and said that there was a clear finding under 3103 that a substantial right of a party was prejudiced. That was the basis for the sanction, not the breach of the orderly disclosure scheme set forth in Article 31. Let me finish by saying, if that were the basis for a $150,000 sanction, virtually all of my colleagues in this room at one time or another have not adhered to a PC order, have not adhered to a disclosure schedule. That certainly can't be the basis for a sanction of this magnitude or any sanction. Thank you very much for the time.
Thank you. Manhattan Christie versus 215 Christie Investors. You may proceed whenever you're ready.
Thank you, Your Honor. Greg Silbert for Plaintiff Appellant. I'll begin with tortious interference. The defendants concede at page 21 of their brief that corporate officers can be sued for causing a corporation to breach a contract if the officers act for their own personal benefit or against the corporate interest. And I know this court is familiar with that rule because you applied it recently in Shear Enterprises against Cohen, and two of you were on that panel. So the question before you on appeal today is, have we alleged that Mr. Witkoff and Mr. Schrager acted either for their own personal benefit or against the corporate interest?
So where in the complaint do you make the allegations that at least let you get past the 3211 stage?
Yes, thank you for that question, Your Honor. Let me give you some paragraphs of the complaint that you can refer to. Paragraph 70, paragraph 74 to 75, paragraph 83, paragraph 94, paragraph 111, paragraph 116, and paragraph 130. Now, those are not all of them, but those are a selection of them. If you look at those and other similar paragraphs, what you see is that we allege repeatedly that these defendants caused the joint venture to take on too much debt that it could never pay, that debt had no legitimate corporate purpose whatsoever except to flood the joint venture with cash, which the individual defendants then funneled out of the joint venture and into their own pockets. So we have to allege either no legitimate corporate purpose or personal benefit. We have clearly and repeatedly alleged both. This was done for no purpose of the joint venture, and we go into great detail about why that is, given the timing of the loans and other factors. There's also consciousness of guilt because they manipulate accounting statements and they don't include us as notice parties on the loan. They then take that money, they send it right out, we're talking over $100 million. They funnel it right out of the joint venture and right into their own pockets. That is a tortious interference claim, if ever there was one. The decision below has to be reversed on that issue. Now, if there are no questions on tortious interference, I'll go to unjust enrichment.
Keep going.
Thank you, Your Honor. Very interesting issue here. We have asserted unjust enrichment against all of the respondents here who are non-contract defendants. Not a single respondent who is before you in this appeal is a party to any of the contracts that are at issue in the case. So the question is, does an unjust enrichment claim have to be dismissed against non-parties to a contract merely because
There's a contract
there's a
with other
contract with other parties that relates to the same subject matter? The controlling law on this question is the Court of Appeals decision in Bradkin, and it's the same rule that this court applied in Georgia Malone in 2011, and it is unequivocal. What it holds in circumstances essentially identical to the ones here is that it doesn't matter if there is a contract with another party, as long as the defendant in the unjust enrichment claim is not a party to the contract.
So the thing is, you have a lot of different defendants named here. And it seems in reading the complaint that the allegations are a little attenuated as to some of these individual defendants, like the last named individuals. I can't really figure out what they did or what you allege they did that could hold them in, even, you know, with the sort of open, the easy way, not easy, but the fact that on a 30-11 motion, we're a little bit more flexible with who we hold in and who we let out. Now, I know Judge Reed let everybody out, but I'm wondering if there's any distinction, because I couldn't find too many allegations in the complaint that dealt with the individual defendants.
Yes, thank you, Your Honor. So I don't think there is a real argument about being too attenuated with respect to Mr. Witkoff and Mr. Schrager. They were the principals of the joint venture and the managing member. They caused the breach. I do understand Your Honor's question about the other named defendants. Those are owners of the managing member, along with Mr. Witkoff and Mr. Schrager. And while they may not have caused the breach, which is why we did not sue them for tortious interference, they did receive the money. And we specifically allege that in paragraphs 94 and 130. So because
it's just like upon information and belief, they got the money. I mean, don't I need something more than that, or don't we need something more than that?
Well, this is at the pleading stage, Your
I
Honor, and once
understand
we
that.
have their accounting statements, those will show definitively whether those defendants actually did receive the money or not. We're pretty sure they did, but if they didn't get any money, then obviously we're not going to try to collect any money from them. If they did, again, we're talking about over $100 million sent out here. So that's a lot to go to two people. Maybe Witkoff and Schrager got it all, but if they shared it with the other owners of the managing member, we have a right to collect from those other members too.
And there's no way to know that at this point.
No way to know at the pleading stage, exactly, Your Honor.
Got it. All right.
Thank you.
Good afternoon, Your Honor. Stephen Meister for all respondents other than Zeal Feldman. Your Honors, in the complaint, there are multiple instances where the appellant has specifically alleged that the alleged breaching payments, which are distributions and related party transaction fees, were paid to the managing member, which is the sole contractual counterparty. It's a two-party LLC agreement. So, for example, in paragraph 57, series of significant and improper distributions to the managing member. In paragraph 62, related party transaction fees were paid to the managing member. Now, the complaint is also clear about how the appellant is alleging that any of this money got to any of the other 10 respondents or defendants beyond the managing member. And in paragraphs 94 and 130, and I'm quoting from the complaint, upon information and belief, the proceeds from these distributions flowed directly from the managing member, that's 215 Christie Venture LLC, to the Witkoff and Schrager defendants and the other 5 individual defendants. So what we have here is they're stuck with their pleading. I didn't write this complaint, they did. They don't allege ever that any of these individuals got direct payments from the joint venture. And in terms of, I'm speaking tortious interference now, in terms of the corporate interest, this is a legal sleight of hand. You had a 2-party joint venture. You had, we call it MCSDF, the regional center subsidiary, and this 215 Christie Venture LLC, which was my client. They were two members in a joint venture. And what they are saying is that the managing member, they repeatedly say this, breached the joint venture agreement by paying distributions and related party transaction fees that they say weren't permitted. The corporate interest, Witkoff and Schrager were not officers of the joint venture. They were indirect members of 215 Christie Venture LLC, the managing member. So when they caused the joint venture to pay distributions and related party transaction fees to the managing member, they weren't acting against the corporate interest, their corporate interest of the managing member. The corporate interest is not the interest of the joint venture. Take the Bradkin case, although Delaware law...
Can I ask you something? Who put this chart into the record? Was it you or was it the plaintiff, this organizational chart?
We didn't put anything into the record. I'm familiar with the...
You've seen it, right?
below?
Yeah, no, this is in the appellate record.
Yes.
So because I was saying that some of your clients aren't, like, don't even, there's a lot of people in these little squares and circles, but I didn't see some of your clients in there, and others I do see there.
If you go to the top of the chart and you track through, for example, Witkoff and Schrager, you will see that Mr. Witkoff is, I think, 3 or 4 entities above the managing member. Mr. Schrager is 4 or 5 entities above the managing member.
Weren't they alleged to be like COOs and CEOs and presidents of the managing member?
But there's no allegation that they were officers of the joint venture. And if you go, this is critically
But
important.
of the managing member they were.
Correct, but not of the joint venture. So if you go to the Bradkin case, because it's very telling, what happened in the Bradkin case is the plaintiff had originated a loan opportunity. And he had a contract that said, if I originate a loan opportunity and my employer makes the loan, I'll get a commission. Then what happened is a non-controlling executive at the same employer usurped that opportunity, made the loan, that the opportunity for which was originated by the plaintiff, and didn't pay the plaintiff. That's acting against the corporate interest. Schrager and Witkoff acted in the corporate interest because the corporate interest was the interest of the managing member. They were not officers or directors of the joint venture.
But aren't they alleged to have tortiously interfered with the contract between the plaintiff, who were investors, and the joint venture by taking money that was really supposed to be for the joint venture?
The only contracted issue here is an LLC operating agreement between the appellant and the managing member that formed the joint venture. So Schrager is a signatory. I mean, not his individual capacity, but his signature appears on the joint venture agreement. So think about what's happening here. They're trying to tag Schrager with tortious interference with a contract that his name appears on as a signatory. He's not a stranger to the contract. And by the way, Delaware law controls, there's a similar rule, it's an affiliate privilege. As for unjust enrichment, the contract is comprehensive. There's there's issues of alleged distributions and related party transaction fees. I'm not going to get into the details because that's for another
'Cause
day.
you're out of time.
But that contract comprehensively covers the subject matter, and therefore there can be no unjust enrichment claim.
Thank you. No, wait, he comes next. Then you.
I only requested 2 minutes, so I'll be very brief and much less than that. As Your Honor correctly pointed out, I represent Zeal Feldman. The only claim against him is not tortious interference, it's just unjust enrichment. And as Your Honor pointed out, and great minds think alike, I have exactly what you were pointing to, the org chart. Mr. Feldman.
I'm not sure if that helped or confused me more, but it was
Well,
interesting.
it's a little confusing, but at the same time, that organizational chart demonstrates there are at least 4 LLCs separating Zeal Feldman from the JV entity and 3 separate LLCs separating him from the managing member, okay? And as an individual, he has no interest whatsoever in the JV entity or the managing member, and there are no allegations in the complaint that he's the alter ego. There was no claim, and by the way, there was an alter
No
ego.
alter ego
Right.
claims.
So there is no basis, as Your Honor quickly pointed
But
out.
it seems your adversary here says, but he collected money from the distributions. Is that incorrect?
Well, whether that's correct or incorrect, I don't think that's been properly pled. If you read what's been pled, it said defendants, and this is record 68, paragraph.
That's not a denial, it's just he didn't plead it.
Well, again, I haven't looked at.
I'm just listening to you very carefully.
We're at the pleading stage, Your Honor.
And lawyers speak real clearly, I got you.
If you look at the record at paragraph 167 of their complaint, it says defendants willfully schemed to enrich themselves by making enormous payments of cash to the managing member. But the problem is, appellant did not make those payments to the managing member. The managing member caused the JV to do so. That's a different set of circumstances. That's precisely why the unjust enrichment claim is just disguised breach of contract claim.
Thank you. Now you.
I believe my colleague told you that Mr. Witkoff and Mr. Schrager did not act for the joint venture. Let me read you page 19 from my colleague's brief. It says, Witkoff and Schrager are themselves the principals of the joint venture, and it cites to the complaint. So they seem to have changed their mind on that, but they were right the first time. Witkoff and Schrager are the principals of the joint venture. I think my friend also told you that Mr. Witkoff could not be liable because he signed the contract that was breached and therefore was not a stranger to the contract. I urge you to read your own decision in Georgia Malone because it is the exact same facts. It was an individual managing member of the corporation. He signed the contract on behalf of the corporation. This court held no breach of contract claim against him because the contract bound only the corporation, not the individual signatory. In the same decision, it upheld an unjust enrichment claim against him because he abused his corporate position to personally benefit himself. That decision then went up to the Court of Appeals, and the Court of Appeals affirmed it is the exact same case. You should reverse and you should reinstate both the tortious interference claim and the unjust enrichment claim.
Thank you.
Thank you.
Thank you, Judge Mendez. Mish versus Good Samaritan. Please wait for my colleagues to return. You may take that the first row if there's extra of you, okay? Is this your copy? Keep it, I'll take a look at it. Okay. Okay, all right. You can bring that chair closer to the table. Yeah, so that she can
see.
No, I'm not talking about this. No, I understand. But it seems weird to have you behind her.
He'll see.
Okay.
He'll
He can
see.
see. You're not blocking the other attorney. You're okay? Okay. All right. You may proceed, sir.
Good afternoon, Your Honors.
Pablo Sosa Queller Fisher for the plaintiff appellant Charles Makish. In this med mal case, we claim that there were departures committed by the anesthesiologist as well as the intensivist and the staff I named for the failure to initially document the depth and the placement that the endotracheal tube was placed during the December 29th surgery. And then thereafter, during the 96-hour intubation period, the failure of the intensivists, two of them.
Do you have a theory as to who it is inflated the ATT cuff which caused the injury to the vocal cords?
The record reflects that the cuff was inflated after the patient reached the PACU, sometime between the PACU and the SICU, which was the evening of the 29th going into the following morning. It was certainly not inflated during the surgery or when the patient had arrived.
At that point, Kagan is not in charge of the treatment, right? It's been handed off to someone, right?
It was handed off actually to a colleague of his in the OR, another anesthesiologist. But the issue against Kagan is that he didn't document the depth that he placed the endotracheal tube or its non-inflation status.
That his failure contributed to the handoff doctor inflating the cuff in a position which caused injury.
That's the allegation against Dr. Kagan because
But wasn't, as I understand it, and maybe I'm wrong, and if I am, please correct me. But as I understood the record, throughout the process, there were films being taken of the positioning. So I'm almost certain that there was a film taking interoperatively, which showed its position. So in light of that, and in light of the fact that he was no longer part of the treatment post-operatively, and there is a film documenting where it was placed, why is that a problem that there is no written record of the placement in light of the films? It would seem to me any doctor who treats him after would have looked at that.
Well, the subsequent downstream providers don't have the intraoperative fluoroscopy images at their disposal. They have to rely on where the patient shows up in the PACU as documented with the tracheal tube measurement at the lip. That's all they have to go
I think
on.
you're not answering Judge Manzanet's question. Wouldn't those doctors have seen the films?
Well, there's no indication that the downstream providers looked at the intraoperative OR films. There are
But wouldn't they be required to? And if they haven't before continuing treatment, isn't that on that doctor and not Dr. Kagan?
Well, that's why we have allegations against the intensivist. But again, the OR anesthesia record is completely blank as to what Kagan did relative to depth placement or non-inflation status. That was our claim against Dr. Kagan, that he should have. If you look at the anesthesia record, it's empty, it's blank.
So was there some place that you can point to in your expert affidavit? I know there were a lot of expert affidavits in this case. And it seems to me that the defendants at least made out a prima facie case as to all their defendants, but you've got one affidavit from an anesthesiologist that had to cover everybody. So where in that affidavit that I've started to look at a couple times and read through, is there allegations as to what Dr. Kagan did that was a deviation from proper and standard medical care?
Yeah, the allegation as against Dr. Kagan, it's basically page in the record 3637, I believe, is where the conclusions are located, and the allegations against Dr. Kagan are in conclusion number 1 of the affidavit. That's the depth placement and non-inflation status.
But your expert goes on to discuss departures by Dr. Blau and Dr. O'Hara, who are intensivists. And it's not clear to me from your expert's affidavit what his or her expertise, he or she is an anesthesiologist, and it's not clear to me how much we know about his or her expertise with regard to intensive care post-operatively.
The plaintiff's expert?
Yes, where do you establish that in your affidavit?
Well, at the beginning of the affidavit, the plaintiff says that he did a fellowship and he has certifications in anesthesiology in both critical.
I understand about anesthesiology. I'm talking about the operative care? Where do you establish his or her expertise with regard to that?
Well, I believe he talks about his qualifications, says that he manages airways and tubes in the ICU, in particular pediatric ICU. That's his experience.
So how is that relevant to this patient who's not pediatric?
Well, I just think that it's not only the pediatric ICU, but also in advanced cardiac life support. He manages airways in ICUs. I believe Judge Edwards had no issue with the qualifications of the plaintiff's anesthesiologist vis-a-vis all the named defendants in this case, including the intensivists.
So in order to accept your theory of the case, we have to accept that they did not look at the films. Is that correct?
Well, the theory of the case from the plaintiff's expert's perspective is that by the time he gets to the PACU, the patient, the tip of the endotracheal tube is at the level of the clavicles, which is 8 centimeters above the carina. And that correlates to 23 centimeters as measured from the lip. And throughout the SICU stay, it remains at 23, then it goes to 24. It's not until after the 4th advancement, or commensurate with the 4th advancement, that they get it to 28 centimeters and push that tip in the cuff into the trachea where it belongs.
Now, I went to law school because I'm not good in math, right? And part of the record here told us that your client's trachea was longer than normal. So it seemed to me that the measurements were kind of cutting it close in terms of there being a problem because he had a little extra room than your average patient.
Well, I'm glad you brought that up. That's a measurement that the defendant's experts came up with. They don't indicate that they actually measured it or the methodology used to measure it, but that's a measurement that they came up with in their papers, I would submit.
But I don't recall your expert controverting that.
Well, the plaintiff's expert controverts it insofar as he looks at the intraoperative fluoroscopy, notes that when the tip is at the level of the clavicles, that's 8 centimeters above the carina. That's his issue of fact. The defendants come up with their measurement saying is a longer than average trachea, which I will say was never mentioned in the anesthesiology record, in any record whatsoever of this patient, intraoperatively, postoperatively, or during his admission. For the first time, this measurement comes up in an expert affidavit from the defense.
Why wouldn't that measurement be able to be verified through the multiple x-rays that you have?
I think that would be something to be verifiable at the time of trial for the trier of fact. If the plaintiff's expert says
I would have liked it right now. I mean, if I had an expert saying that measurement is off, then their entire theory is off, right?
That's a fair point, but once the expert says, the plaintiff says it's 8 centimeters above the carina, the tip of the endotracheal tube is in the vicinity approximating the cords, that's your contradiction, that's your issue of fact, because we know from all of the radiology records that were obtained subsequent to the OR, 8 centimeters above the carina equals 23 centimeters at the lip with the tip at the level of the clavicles. That's where it remained until the 4th advancement. That is the issue of fact. The plaintiff says at that level, 8 centimeters above the carina, it's approximating the cord and causing repeated compression injuries.
So your expert discusses the fact that there was a traumatic intubation as related apparently by an oral report by Dr. Bonafide. Where does that fit into this, that perhaps the whole problem stems from a traumatic intubation?
Well, Judge, it doesn't actually, because Dr. Bonafide in a note wrote questionable traumatic intubation, but then everybody, including the plaintiff's experts, said that there was no indication in the anesthesia record of a traumatic intubation, and that as a cause was ruled out.
But your expert acknowledges that there may have been an oral report about this.
I'm sorry, Judge?
Your expert discusses the possibility of there having been an oral report of it.
Well, the expert talks about it in the realm of medicine, it's a possibility, but in this case, there was no evidence of a traumatic intubation. That as a cause was ruled out.
Thank you. Okay, who's next?
Good afternoon, Your Honors. Jonathan Waldauer from Rubin Paternity. I represent Good Sam and the 3 non-physician employees of the hospital. I'm going to address the first issue about the length of his trachea. Those were measurements made by our experts, specifically my expert and one of the other defendants' experts, based on radiology images. So that is evidence, that is opinion evidence from experts. It's completely admissible at this point. It was never refuted by plaintiff's expert. And there's one argument that the plaintiff made that I'd like to address in terms of, well, those are just points in time. These are x-rays over 96 hours. They're just points in time. But if there's a car coming from Albany to Buffalo, and it takes...
Well, let's not talk about a car. That's not even...
Well,
we're talking about a finite space.
We are talking about a very finite space.
And when I'm talking, you shouldn't be.
I apologize.
Okay. So it seems to me that the issue here is whether there is sufficient statements in the expert reports by your side that are not controverted by the other side.
So
what do we have there?
Okay. Apologize for speaking while you were.
It's okay.
Yes. So the first is obviously the causation argument that I'm addressing right now with in terms of our experts show that the pressure cuff was never inflated at the point of the vocal cords, which is their explanation for how this injury occurred. And that was based on measurements by x-rays along the entire 96
When the record says adjustment, what does that mean?
So adjustment means you're pushing it down. So somebody takes the tube, pushes it a little further down their throat. The carina is right about here. I'm pointing in between the chest. The vocal cords are here. You want the tip somewhere in between. And the cuff is inflated to make sure that there's a seal for
so that it
pressure.
doesn't move.
The air pressure is being pushed into the lungs and not that air is escaping at the same time. It doesn't always have to be inflated because you don't always need air pressure being forced in. In fact, during the surgery, it's not inflated because he was breathing on his own when he started surgery, and they wanted it to be able to move so that it didn't cause injury, and because he needed the surgery that was done. So to just go back a step, he has a very bad bicycle accident. He's brought by ambulance to Good Samaritan Hospital. He has to undergo a neurosurgery from the front and from the back. And then have large plastic surgery done on his face.
He fell on his face.
He fell on his face. He couldn't move his arms and his legs. So he's brought into the hospital. They determine what they need to do, and they do part of the surgery from the front, part of the surgery from the back, which means he's got to be flipped over in the middle of the surgery to be done. And then he's taken to the PACU afterwards. Immediately, they do an x-ray to determine where the placement is. They say it's a little high, they push it down. They do periodic x-rays throughout. It moves up a little bit, they push it down. It moves up a little bit, they push it down. That's what happens over and over again. That's not unusual. That's why they're doing the x-rays, because it will migrate at times up and down. And when he wakes up, he has vocal cord injury. We don't know exactly when or how that happened. We do know he was in a pretty serious accident, and he had extensive surgeries. And we also know...
Is there a claim as to any of your clients that there was an extensive period of time during which either the films weren't taken or nothing was done in response to the films in terms of moving it to the appropriate place? Does that involve your clients?
Yeah, there's a particular allegation with regard to that.
So
but
it's
there's a
honest,
long...
I'm sorry. It's honestly, it's difficult to understand who the claims are against because it's just very broad that this was done and these people were carrying.
Your clients are not actual doctors.
My clients are not doctors.
You have a nurse and a
respiratory therapist
and a PA. Right.
All people who are largely following orders of attendings.
But they are also people who are mostly in contact with the patient.
Yes.
Right.
And so there's, the plaintiff does have claims that we went too long without taking an x-ray, that, they waited too long to adjust it. They made all those claims. And in response, they're not specific to anybody, number one. And so we don't know who's responsible according to the plaintiff's expert affidavit. But even putting that aside, we have the films that show the cuff was not at the level of the vocal cords. So there's no way to, there's no causation in the end, regardless.
At no point, I want to make sure that I'm understanding what you've just said. At no point was there ever a documenting of that cuff being at or near the vocal cords, is what you're saying?
That's correct.
Okay, thank you.
Thank you.
May it please the court, Nicholas Herzler for Dr. O'Hara. Your Honors, an important point here with respect to my client is that she had very limited contact with this patient starting on December 30 at 3:10 p.m. until January 1st. And we submitted our expert's affidavit that showed that at all times during that period of time, that the tube was in the correct position. The plaintiff, just now during oral argument and in the reply brief, when pressed as to when exactly was the tube in the wrong position and what were the measurements in response to Dr. Stone, the response referred, I'm looking at plaintiff's reply brief I'm looking at the record at page 3615 and 3616. So what they refer to is during the intraoperative fluoroscopic images. So when counsel refers to the measurement of 7 or 8 centimeters above the carina, that was during the surgery. Like, my client did not see this patient until a day after the surgery. And by the time that this patient was seen by my client, the tube had been adjusted several times by other professionals, and it had also been secured in place with the commercial holder. And the law is clear that a physician may limit her duty, quote, to those medical functions undertaken by the physician and relied upon by the patient. That's from the Markley case. And so my client was not responsible for this particular issue of adjusting the tube and inflating or the cuff at a particular time. That was being taken care of by other professionals who were constantly, on a regular basis, measuring with x-rays and then adjusting the tube as necessary. And so there's no evidence whatsoever in this record that Dr. O'Hara breached in any way a departure from the standard of care, or that she did anything or did not do something that proximately caused any injury to this patient. We also do object to the qualifications of the plaintiff's expert insofar as it's not established, as Justice Gesmer alluded to earlier, that it's not established that the expert has the requisite qualifications. It was also an anonymous affidavit, and the procedure was not taken care of to state in the opposition papers that it was an unredacted version of the affidavit was ever provided to the court in camera. That should have been done, and it was not.
But doesn't the plaintiff's expert affidavit have a specific allegation as to your client at 3638? Because that concerned the delay in ordering a chest x-ray, which was, I believe, during the admittedly brief period when your client was involved in decedent's care.
Well, it wasn't my client. There were many times when chest rays were ordered by numerous different physicians, but that was never that was not something that my client was ever supposed to be working on or taking care of. She was supposed to be evaluating him for other issues. There was never any allegation or claim that she was supposed to be ordering an x-ray or anything of that nature.
So Dr. O'Hara was checking to see when this patient could be weaned off of the tube.
Correct. And he could not be.
So the positioning of the tube is irrelevant to a doctor whose function it is to decide when that tube should be removed?
It's not that it's irrelevant. It's just that they had taken x-rays and determined where the tube was, and she knew, that where it was, and that they had in the flow charts, there are specific measurements as to exactly where it was at all the time during the times that she was there with him. Okay. And so there's no evidence of any act or omission that when she was treating him that it was misplaced.
The plaintiff's expert says there was a 9-hour and 50-minute delay in ordering a chest x-ray. Is that something which is charged against Dr. O'Hara?
No, Your Honor. I mean, I don't have right in front of me that
Well,
9.
it's in that paragraph, because I do have it in front of me.
Page 36, 38.
Right. That was claimed as to Dr. Blau, Dr. O'Hara.
As my
Mr.
colleague
Norton.
said earlier, there's no evidence that the tube was out of position before or after that time period, and there's no evidence that it was out of position during that time period either. And there's also no evidence that my client was ever ordering the x-rays or was in charge of ordering the x-rays, or that was within her delineated care that she was supposed to be doing for this patient. That was being taken care of by the respiratory therapist and the other professionals.
So you're saying that it would have fallen to the respiratory therapist to order x-rays rather than to your client, the doctor who was the intensivist in charge at that time?
That makes no sense.
It was also in place with the commercial tube holder, but
No, I want an answer to my question. Are you saying that it wasn't your client's obligation to order an x-ray during the time she was on duty? And are you claiming instead that it was the obligation of a respiratory therapist instead of an MD?
perhaps if there was any evidence that it was out of position, Your Honor, but there was never any evidence from any of
But
the
that's not what I'm asking. I'm asking whose duty it was. And a few minutes ago, you said it wasn't your client's duty to order chest x-rays, and that fell to the respiratory therapist. Is that really what you're saying?
Your Honor, let me amend that a little bit. I'll concede that, yes, if it was out of position and that she was there and she knew that it was out of position, then yes, she would have been responsible to order an x-ray.
Getting back to page 36, 38, it says following, next to the last line, following a documented 5-centimeter proximal migration of the ETT. And in the face of that, the chest x-ray should have been ordered, and it was a 9-hour and 50-minute delay. Where does that fit into all of this?
Your Honor, there's no evidence.
Why doesn't your client bear a responsibility for that?
Because she had no notice at any time during that period and that it was out of position at all. It was in place with a commercial tube holder. It had been clipped into place, and she was relying on the other professionals.
The experts say that this moves, that if you cough, if you shift even your body a little bit, it could migrate. And there's evidence saying that it had migrated. So I agree with my colleague. There's no way that the respiratory therapist has more of a duty than the doctor.
Your Honor, there were other doctors that were treating this patient, not just the
I
respiratory
understand that,
therapist.
obviously.
But during the time your client was the intensivist, wasn't she the primary person responsible for the decedent's care? And as you said, it was only about 24 hours that she was in charge, but wasn't she the primary person during that period?
There's nothing in the record to suggest that she was in charge or that she was the primary person, but I mean.
Who do you think was in charge while she was on duty with regard to the decedent?
Your Honor, I can't name any one person in particular who would be quote unquote in charge. There's nothing in the record to say that there was any one person who was in charge. But I also want to point out one last thing, is that there's an issue of a missing transcript.
A missing what?
Transcript, the oral argument transcript from the motion practice in the lower court, the motion for summary judgment. That transcript should have been included in the record.
But we have a very long and detailed decision from Judge Edwards that we can work off, so I don't think it has to be there.
Thank you.
Thank you.
Just, what's the date that your client was in charge? Is that December 31st?
December 30th, 2013 at 3 p.m. until January 1st, which was after he was extubated.
Thank you.
Which is when the 9-hour period.
12:31.
Good afternoon, Justices. My name is Joyce Lipton, and I'm with the firm of Wagner, Doman, Lido, and DeLeo, and I represent Dr. Kagan and his anesthesiology group. We all know that expert opinion, as well as any allegations, have to be based upon facts in the record. And I would submit to you, as I did in my brief, that the claims of departures against Dr. Kagan are not claims that can be supported by the actual facts. The facts that plaintiff is relying on are erroneous.
How so?
The argument about the malposition of the tube is based upon a claim that Dr. Kagan placed the tube between 2 and 3 centimeters above the carina. Dr. Kagan placed the ET tube 2 to 3 centimeters up in the tracheal rings above the carina. So he went 2 to 3, please let me withdraw the centimeters. Now I'm getting confused. He placed the ET tube 2 to 3 tracheal rings. It has nothing to do with centimeters. And in fact, plaintiff's expert testified, not testified, but put in his affidavit, that he agreed with Dr. Kagan's objective to place the ET tube 2.5 to 3 tracheal rings above the carina, and said that this would reflect appropriate placement of the endotracheal tube. He then goes on to say that the endotracheal tube was placed 2 to 3 centimeters above the carina. There's no evidence, there's nothing in the record, and I would suggest that this was a typo of some sort or error, and he said, well, that's wrong to place it to.
Well, your adversary says part of the problem here is that your doctor failed to record this. And that instead of having to rely on the opinions of radiologists looking at films later, he does not, as a part of his interoperative report, lay out the actual placement as is required.
The claim is that Dr. Kagan did not provide the depth of the tube in the chart. He did not record the depth of the tube. He doesn't have to, excuse me, because the tube contains markings and tells you the depth of the tube. It was 23 centimeters from the lip down, and that is the depth of the tube. So you have a tube telling everybody what the depth is. You don't need to put it in the record when the tube has the markings, and that was unrefuted, that the tube contains the depth of the tube.
So you're saying it's not a standard of good care to indicate where it was inserted? At what point?
It's the standard of care to have a tube that tells you where the depth is.
So you're saying the tube is 23 centimeters long, and if it's hanging from the lip, that's what we know?
No, the tube is longer than that.
Okay.
And what you do is you see where it is from the lip.
How do you see?
Because it says on the outside, 23 centimeters, 24 centimeters. It has all the measurements.
So there's extra tubing that hangs out of the mouth, you're saying, and so that you know what's left?
You pull it
Is that what you're
down.
saying?
I'm saying that it has the markings so that if it says 23 at the lip, you know that the depth is 23 centimeters. That's how you tell. It's like a ruler. If you have a ruler down there and you see up here that the ruler is 11 inches.
I just asked you a question. So this ruler, okay, to use your analogy, this ruler, there's a part of the ruler that's still hanging out. So it tells me there's 23 because 24, 25 is hanging out of the mouth.
Correct.
Okay.
But it seems that the expert for the plaintiff says, and you can tell me why this is wrong, that that the doctor didn't specifically document the position. You're saying it would be obvious, and that it would be especially important in cases like this one where the plaintiff will be going from the supine to the prone position. Does that not make any sense in this case?
It doesn't.
And why?
He doesn't mention that he doesn't mention that it's on the tube. So yes, he didn't put it in.
Yeah, no, but you're saying I'm laying this way, the tube, and if you flip me upside down, there's no shift whatsoever.
There could be a shift.
Okay.
But the tube still says.
But you'd know it
23
because the tube would show it?
The tube, no, because it's taped to the lip. There's no way of knowing where that tube shifts a little bit, unless you take films, and there were films taken, and the films showed that it was in acceptable position. That's not why the films were taken. I know I'm out of time.
Okay, until we tell you to stop, you keep going.
So are you saying it's not important for the person, for the doctor who initially places it, to document where it's initially placed?
It is initially placed 23 centimeters. The documentation is on the tube itself. The reason they do a post-op X-ray.
But do you agree that it can shift?
It can move a little inside, and you can't see it. And there's no way to see it until you take that post-op X-ray. That's why they immediately ordered X-rays within 3 minutes of the patient getting into the PACU, because they wanted to see if the tube moved. That is how you measure it. That's how you check it. And that's why within 3 minutes, and then within several minutes thereafter, they noted where the tube was. That's the only reason they take an X-ray.
Okay. All right. I have a question. I'm sorry. Dr. Bryson was your expert, correct?
Yes.
Dr. Bryson opined that if there had been a traumatic injury, that there would have been signs of trauma when Dr. Bonafede evaluated the patient, and there were none. Did the plaintiff's expert contradict that anywhere in their report, if you know?
No.
Thank you.
Good afternoon. I represent Dr. Reed and Dr. Blau. Dr. Reed's summary judgment has not been
Could you
opposed.
lift up the mic so we can hear
I'm
you a little
sorry.
bit?
Lift the mic up so we can hear you.
Dr. Reed's summary judgment was not opposed, so I'll focus on Dr. Blau, and I'm going to try not to be redundant because I know there is a lot of crossover here. The court below appropriately focused on the failure of the plaintiff's expert to provide a non-speculative, specific, non-conclusory opinion about proximate cause. And with respect to Dr. Blau, she said, he failed to specify with sufficient detail how Dr. Blau's care or his orders deviated from good and accepted practice and how they approximately caused the plaintiff's injuries. The language was vague and failed to provide sufficient evidentiary basis to support his or her opinion that the ET tube was malpositioned too close to the plaintiff's vocal cords and recurrent laryngeal nerve, or how the positioning of such ET tube caused the injuries and when such injuries occurred. Because the plaintiff's expert clumped everybody together, the affidavit is just per se insufficient. For example, there's 4 paragraphs that deal with the expert's opinion. The first is specific as to Dr. Kagan. I'm going to skip to the third.
Do we have to read that in view of the expert's recitation of the facts, which distinguishes what Dr. Blau did from what other people did?
Well, I would put forth that he did not specify what Dr. Blau did or didn't do, and Dr. Blau was supervising for the first night after and morning after the surgery. He was on immediately in the PACU, and then he was on the next morning, which was the 30th, but then the 30th and the 31st, Dr. O'Hara was the SICU attending. So during the time that he was supervising, yes, he was in charge of overall supervision. But for example, paragraph 3 talks about Blau, O'Hara, Naughton, Ashnuden, and GS failed to timely order chest x-rays on 12/31/13 at a time when the tube had migrated 5 centimeters, approximately 9 hours and 50 minutes. Now, Dr. Blau wasn't even on call at that point. He wasn't treating the patient. So right then and there you have a problem. The prior paragraph talks about the failure to order x-rays within the preceding day when he was on call, but it fails to acknowledge that x-rays were ordered at 4:34 a.m. by radiologist Dr. Brian Weber, who then ordered that the tube be advanced. So he doesn't accurately portray the record. And the expert also fails to refute multiple things that my expert, Dr. Salzman, talks about. For example, that migration of the tube is somewhat common, and that it is also
So
common.
your point about paragraph 3 is that it's not apparent who it is that should have ordered this x-ray among the various defendants.
In paragraph 3.
In paragraph 3.
My point is that my client wasn't on duty.
At that time.
At that time.
So was there anything that was specifically alleged as to your client during the, I guess, 24 hours or maybe less that he was in charge?
I mean, in a general sense, in a supervisory sense, yes, but for example, he said that there weren't x-rays done in the preceding 9-hour period, but there was an x-ray done at 4:34 a.m., so that is not correct. He also can't attribute any delay to Dr. Blau when the patient gets admitted to the PACU at 7:42. The X-ray is done at 8:45, and the order by Dr. Blau to advance the tube is 15 minutes later. And my expert said that was sufficient, it was timely, and their expert did not refute that.
Thank you.
Did your, I'm sorry, one more question. Did Dr. Blau overlap with Dr. O'Hara at all, or was he succeeded by Dr. O'Hara?
No, Dr. Blau was the SICU intensivist immediately after the surgery, and then Dr. O'Hara took over the 30th and the 31st.
Okay.
Thank you, Your Honor. Just very briefly, the citation of the record at 3615 and 3616, that is where the plaintiff's expert documents states that when the tip is at the level of the clavicles, it's 8 centimeters above the carina, that's where it is compressing or in the vicinity or approximating the cords. That's the issue of fact with this measurement that I indicated earlier had cropped up for the first time at the litigation stage. And I will also...
But can you identify with specificity, as counsel was just raising, what actions Dr. Blau took in, I guess, the period from looks like 9:40 p.m. on December 29th until 3 p.m. on December 30th, when Dr. Blau acted in some way that was a deviation?
Well, it's a supervisory, a closed circuit duty that we're alleging here. They are the top or the tip of the spear, if you will. It's funny, or I shouldn't say it's funny. It's the defendants are claiming that the PA and the RTs were doing things and they're not responsible for it, but yet in their papers, there's a statement that's made, everybody reports up the chain of command to the intensivists, Dr. Blau and Dr. O'Hara. So it is that supervisory duty.
But your expert lumps together in the paragraphs in conclusion, your expert lumps together Dr. Blau and Dr. O'Hara. How are we to separate those?
Well, the body of the papers specifies minute by minute who is doing what and at what stages the malpractice was occurring, when the tube needed advancement. That falls within the umbrella of Dr. Blau's and then thereafter Dr. O'Hara's supervisory timeline, so to speak.
That was just the conclusions at the end of a 30-page affidavit that goes through the more details.
Yes, Your Honor. Yes, I would just add, lastly, the defendants or Dr. Kagan's anesthesiologist, Dr. Bryson, who's also an anesthesiologist, noted that the place where Dr. Kagan, recollecting at the time of testimony as to where he had placed the tube, because there's no record of it, said that depth is the typical depth placement for males. And that contradicts this longer than average trachea that, again, we're hearing for the first time. If it's placed at the typical depth placement for males, then certainly back then somebody would have said, hey, this patient has a longer than average trachea, we've got to place it at a different depth. That was never done, never raised. We have issues of fact left and right. I think that Judge Edwards respectfully overlooked these issues of fact, credited that measurement, and ignored, as I indicated, 3615, 3616 of the plaintiff's brief, where we say there's an issue of fact as to the compression on the cords. Thank you very much.
Thank you so much, all of you. Zeng versus Centers Urgent Care. You may proceed.
Thank you, Your Honor. May it please the court. My name is John Scola on behalf of plaintiff appellants and cross-respondent Jamie Zhang. Initially, I'll just take my appeal first. This is the issue and with my appeal is whether my client sufficiently pled a claim for intentional infliction of emotional distress.
So I have a particular question about that. Your allegations as to the injury suffered by your client are rather general and conclusory. Are there any cases, I could not find any cases where an appellate court upheld or failed to dismiss an IIED claim where the allegations of injury were that general. Can you point me to any?
I don't have a case off the top of my head, Your Honor. I will say that the severity of the intentional infliction of emotional distress on my client would be borne out in discovery. It was severe.
Well, but,
Yeah, but you
where are
know.
the allegations?
Well, he suffered severe emotional distress.
But usually,
That is the claim.
usually we expect a claim would be a little more specific than that, and it seems to me that allegations that are that general often result in dismissal of are consistent with dismissal of IIED claims. So you can't point us to any that have been sustained where the allegations as to the injury are that general.
No, I don't have a case on the top of my head, Your Honor.
The cases that you do cite in support of this cause of action seem so far afield. I mean, like, for instance, you rely upon Scholar versus the City of New York, which is a case involving a custody battle. They bring in a sergeant with the New York Police Department to engage in an unconstitutional interrogation of the plaintiff there, and they search her apartment. There are false reports to ACS. I mean, it's so unlike what you have here. How do you?
So, I mean, to that point, I mean, that particular case, I think, was cited for an example of a case where intentional infliction of emotional distress was upheld. I will speak to this one, though. This case is different than the case.
There's an abuse of power there. I mean, you're involving the NYPD, a sergeant who probably had no business in being involved in that. There's unconstitutional activity taking place, false reports to ACS.
So I would say that the defendants in this case used their power to falsify records against my client ultimately and terminate his employment.
No one's supporting that sort of behavior, but this is not talking about bringing in the NYPD, making false reports to ACS.
No, I mean, I'm not going to argue that case is a good site.
Your other cases are also far afield from the sort of improper behavior. It's far more of an abuse and egregious than it's not just in an internal misbehavior.
I would say that conspiring to falsify records to terminate the first employee might have led to that finding, but the second act, where another employee complains about the falsification of records for COVID vaccines and over-dilution. They do the same playbook. First of all, before they even got to that, the woman, Mirica, responsible for that, discussed this openly with the CEO and my client. Then my client files the same complaint, and they do the exact same fraudulent playbook to terminate my client. I would say that is an abuse of power and would rise to the level of a campaign of harassment toward intentional infliction of emotional distress.
Okay, you'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is Diane Winholtz. I'm with Jackson Lewis, and I'm representing the respondent and the cross-appellant in this case. Your Honor, I would agree with you that obviously the Scholar case presents very different facts, and actually there are a number of cases that present much more similar facts where the courts have denied intentional infliction of emotional distress claims that don't involve an abuse of power.
What do you claim is the closest factually case?
Closest
case factually?
Yes, Your Honor. The case of Hurley versus Metropolitan Museum of Art from this court, a First Department decision in 1995. In that case, the plaintiff alleged that several of his co-workers had falsely accused him of anti-Semitic remarks and brought a claim for intentional infliction of emotional distress.
But that wasn't a situation where the employer incited his fellow employees to bring false claims against him so that they could terminate them, right? It's quite different from this, isn't it?
Well, in that case, the plaintiff was also terminated based on the false claims.
But in that case, the employer hadn't caused the co-workers to complain, right?
That's correct, Your Honor, yes.
That's very different, isn't it?
Yes, okay. Another case, though, Your Honor, Gay versus Carlson is not from this court. It is a Second Circuit
Counsel,
decision.
Look, what your clients did here was not a good thing. It's outrageous on its face. Outrageous, okay? Now, whether it reaches the legal level to do something about it is a different story. but there's nothing to feel proud about in terms of the allegations against your client.
Your Honor, I 100% agree with you if the
Yeah,
allegations
seeing as
are
it's
true.
the second time they've done it.
If the allegations are true, Your Honor, then it is entirely outrageous to engage in that sort of conduct. Obviously, my client denies having engaged in that
Right,
conduct.
twice. He denies having done this twice. Because two of his employees say that they urged fellow employees to make false complaints about them. So, you know, one time maybe, two times lightning doesn't usually strike in the same place twice.
I understand what you're saying, Your Honor, and again, I don't disagree with you if the allegations are true, that it would be outrageous conduct. Again, my client does not agree with the allegations, but again, the cases don't support a claim for intentional infliction of emotional distress, even with these sorts of claims. And again, I would refer the court to Gay versus Carlson, a Second Circuit 1995 decision, where 12 employees were asked by Pan Am to submit complaints against an employee, and the court affirmed the dismissal of that claim for intentional infliction of emotional distress. Your Honors, I think that intentional infliction of emotional distress claims are really reserved for the most egregious allegations of conduct. And Your Honor, I would suggest perhaps even like the Waterbury versus New York City Ballet decision, which is a more recent decision.
I suggest to you that had plaintiffs supported their IEED claim with some psychiatric records or such, we might be having a different conversation, okay? So I don't think that that part of the requirement has been met. But on the outrageous part, I think they're there, okay?
Your Honor, can I be heard on the 740 claim?
You have 30 seconds.
So on the 740 claim, this is pre-amendment of the 740 claim, and it's a very stringent standard. There needs to be an actual violation of a law, rule, or regulation that has
And there
not-
is here.
There-
The rule said that if there was a mistake, then you follow this. But your client was diluting COVID vaccines by 0.1 above what CDC required. So there was a violation.
Your Honor, CDC requires that the dosage be 0.3.
1.8.
The dilutant should be 1.8.
Right, and
Correct, Your
your
Honor.
client was doing 1.9 as a matter of course, not by mistake, not oops, on this one, we got it wrong. That was their standard their modus operandi was to dilute by 1.9 instead of the 1.8 that the CDC required.
The CDC envisions that there are extra dosages as long as the actual vaccine.
And they
has
told you how
0.3.
to pull it out of the vial for that extra dose, right? An extra long needle, etc. Not to just, as a matter of course, dilute it above what the CDC guidelines required.
The guidelines require that there be 0.3 milliliters of vaccine.
Counsel,
given to-
you're really gonna
I'm
try
sorry,
to
Your Honor.
debate this with me?
I'm sorry, Your Honor.
The CDC said 1.8. Have I said anything that is incorrect?
The CDC does say 1.8.
Okay, and
as
your
well.
client did 1.9 as a matter of course. Am I correct?
Not as a matter of course, but the
Really?
allegation is that there was 1.9 milliliters.
All the evidence in this record says that that's what they did, 1.9 as a matter of course.
Your Honor, may I be heard in just one final point regarding the substantial and specific danger to the public health and safety? Because I don't believe that there's been any evidence or any allegation that this presents any sort of danger to the public health and safety.
But counsel, if your client thought it was consistent with the CDC guidelines to use 1.9 as the dilutant, why did they tell their employees to lie about it?
Well, that's the allegation, Your Honor. In fact, and this is not in the record, Mr. Palazzo.
Then we don't want to hear
Right,
it.
okay.
It stores the record.
Your Honor, the CDC guidelines specifically say if anything more than 1.8 diluent is used, nothing else needs to be done.
In the event there's an error, right?
Error or
They were not suggesting that this is what should happen all the time, at all. And your attempt to argue that, to me, is just beyond the pale. Okay?
Thank you, Your Honors.
Counsel, I'll hear you on your remaining time.
So I would just submit that.
So you allege that the basis for your 740 action is that there was a violation of a rule, regulation, or law, right?
I have multiple.
And you point to CDC guidance. Is CDC guidance something which is published in the CFR?
I'm not sure what the CFR is.
The Code of Federal Regulations.
I'm not sure, Your Honor. I don't know the answer to that question.
So what is the regulation, when we're talking about a rule, regulation, or law, we mean a statute, do we not, or a government-adopted regulation, which appears in something like the CFR. So and I understand that there's case law which says that you do not have to allege the specific rule or regulation that was violated in order to state a 740 claim. But so it may not be determinative of your 740 claim, but you're relying on the CDC guidance, but you don't know that the CDC guidance stands as a regulation?
I do not. It's a novel issue with COVID. I will say, though, that regardless.
So the other thing is that there's also got to be a matter of a violation of public health. But isn't it also true that the CDC guidance recognizes that you could get 7 vaccinations out of the vial instead of 6? Now, the recommendation or the guidance was to dilute with 1.8, but at the dilution of 1.8, it was possible to get 7 vaccinations out of the vial.
This is a fact-specific question.
That's in your brief. That's in your brief.
That what?
That you could get 7 vaccinations.
You can, depending on how much is in the vial. But it's moot for this point, though. And the reason why is because paragraphs 102.
Where in the face is that, is there a public health danger in this?
So can I just address your point that might negate this line of questioning altogether? One of the allegations that is in the complaint is that my client refused, after he complained about the overdilution of the vaccines, to falsify records about the vaccine. Committing fraud is a violation of law. That by itself is a violation of 740C. If you look at paragraph 140 of our complaint, it says the defendants discriminated and retaliated against plaintiff because as a result of voicing concerns regarding the public health and safety, more specifically, the overdilution of the COVID-19 vaccines, improperly mixing vials, and the falsifying of the amount of vaccine doses given by the defendants in violation of New York Labor Law 740. That fraud covers 740. Whether or not the CDC guidelines rises to a regulation or a guideline or the CFR, I'm not sure. I think we would flesh that out in discovery. It's pled that it is a violation. I think that's the standard here. But that fraud allegation that he refused to engage in is sufficient for this claim. Now, I will say here that under Moore, the Court of Appeals case in Moore, the court has to take it as true plaintiff's pleadings. It's our belief that the employer on multiple occasions engaging loyal, thank God our employees are loyal was the comment, to file fraudulent complaints would rise to the level of intentional infliction of emotional distress. If there is a question about the severity of damages, I would urge the court to remand the case to determine whether or not that my client suffered those injuries rather than outright dismiss that claim now.
Thank you.
You're welcome. Thank you.
You have 2 minutes.
So first, Your Honor, in answer to your question about whether the CDC guidance is in the CFR, it is not in the CFR. It is entirely just a guidance. It is not a rule, regulation, or a law. Second, the CDC guidance was published on May 18th, 2021, only days 2 days before Mr. Zhang allegedly complained for the first time about the over-dilution. Finally.
But if part of his claim is that he was asked to lie about that, isn't that a separate basis for his 740 claim?
That he was asked to lie about
the
dilution?
The company's dilution practices.
Well, being asked to lie about something is not a violation of a law, rule, or regulation, and just the act of being asked to lie is
asked to lie if you followed a CDC guideline for a pandemic condition. Really?
Again, Your Honor, the CDC guide is a guidance. It's not a law, rule, or regulation. The only requirement under the CDC guidelines, the DOH guidelines, and the Pfizer guidelines on the administration of the vaccine is that the recipient get 0.3 milliliters of the vaccine. And that's why the CDC guidance specifically has a section for errors and deviations. A deviation isn't always an error. Sometimes it's just a deviation. And
except where the company has a policy, which is what's alleged in the complaint here. If this had happened occasionally, we'd be in a very different situation. But the allegations in the complaint are that it was a standing policy in this company. Don't you see that as different from it's something that happened now and then?
And the guidance said if the vaccine vial is diluted according to recommendations, which here it was not, and the low dead volume syringes and needles used in your preparation allow for a full 7th dose to be removed from one vial, Pfizer Medical Information is not aware of any information suggesting that the dose should not be used.
Correct.
That's what it said.
Correct, that the 7th dose should be
not diluted at a formula different than what we suggest and pull it out that way. That's not what that said.
Your Honor, the DOH guidance specifically says that the vials of both Pfizer and the Moderna are expected to contain at least one extra dose.
New York State Department of Health guidance regulations said vials of Pfizer BioNTech are expected to contain at least one extra dose, depending on the type of needle and syringes used. Additional vaccine may remain in the vial. Vaccine administrators may use an extra vaccine that can be easily drawn up in a syringe to meet the full dose requirements. Again, not that you achieve that by diluting at a different level than is recommended by CDC. That's the point. Okay? Thank you. People versus Suchin. You may proceed.
Thank you, Your Honor. Sylvia Lara Altrider of the Legal Aid Society on behalf of the appellant, Suchin. May it please the court. This court should replace Suchin's criminal conviction under indictment 1491-21 with the youthful offender adjudication. At the time Suchin was arrested, he was in the 10th grade. Teenagers are, as a matter of brain development, more impulsive, less able to exercise judgment, more susceptible to peer pressure, and less able to assess the consequences of their actions. The youthful offender statute exists to recognize—
He received the benefit of that on the initial case, on the more egregious one, quite frankly. So he should get that 2 times?
So this was his initial case, but yes, he did receive a youthful offender adjudication on the 2 more serious cases. Notwithstanding that, these offenses, they were very serious. They took place during a 6-month period when he was in the 10th grade.
There are 3 serious charges, 3 separate serious charges against him, right?
Yes.
And while he's awaiting sentences after having been given a favorable resolution on those, at least on 2 of those charges, he then commits a 4th felony, right?
Yes, he is charged with—
And it's at that point that the judge says she's not going to give YO, right?
He is, his open plea at that point is ended, but—
So what's the standard of review? I mean, Is it some sort, I mean, are we to say that the judge abused her discretion in denying the YO at that point?
I don't think that's necessarily true. I think this court, in the same way that it has the authority to reduce excessive sentences and substitute its own judgment, it could substitute its own judgment here.
But why would
Why
we?
would we? He got YO on the rape, he got YO on the gang assault.
Suchin, he is still a young person. The idea of the youthful offender statute is that the things that you do, no matter how terrible, no matter how many people, you are still entitled to you can still earn a second chance.
Counsel,
It's a third choice.
the court said, I'm sorry. The court explained everything. Postponed sentence, he gets rearrested for grand larceny. On the criminal possession of the weapon in the second degree, he could have faced 15. He got 3.5. On the gang assault, he could have faced 15. He got 1 to 3 to run concurrent. And on the rape, he could have faced 25, and he got 1 to 3 to run concurrent. And even with all that, he gets arrested for grand larceny in the 4th degree. And you want us to use our interest of powers to what?
To replace his criminal conviction with a youthful offender adjudication. He's turns 21 next week. He's been in prison since October 2022. For all the reasons that the court found were mitigating in the other 2 cases, and that the prosecution found mitigating and offering a misdemeanor.
At what point, though? I mean, look, I was with the judge in giving this young man a break, right?
Yes.
And how does he show his appreciation to the court for that? He goes out and gets arrested for another felony. At some point, the system has to say, you have to take accountability. So why is this not appropriate accountability? Because he still got the YO.
On the rape.
And she could have blown the entire deal. Okay? You know that. She could have said, oh, you disrespected my court. You left here after I give you a break and you commit another crime. Now you get no YO. She doesn't do that.
Yes, Your Honor.
Why should we undercut this judge then?
This court has,
I know we have the power. The question is, why should we exercise that power for someone who, frankly, has not shown deserving of it?
These were serious offenses. They should not define the rest of his life. He will leave prison sometime next year, and he will return home. His plan is to return with his family and reconnect with the supportive services that he was provided during his open plea. But he will still have a violent felony conviction on his record that will make it much harder for him to find work, to find housing, to go about his life. And this court has the opportunity to change that for him. Thank you.
Good afternoon, and may it please the court, Caroline Williamson for the people. Defendant's single conviction was the product of overwhelming generosity on the part of the trial court, and there's no basis to overturn it or reduce his sentence. As a threshold matter, each of his appellate claims is foreclosed by his valid waiver of appeal. Every aspect of the record supports the conclusion that he waived that right knowingly and voluntarily, so there is no reason even to reach the merits. But out of the 3 violent felonies to which defendant pleaded guilty, he was denied youthful offender treatment for only 1, the armed violent felony offense of second-degree criminal possession of a weapon. This conviction will not define the rest of his life. If he can rehabilitate himself, the conviction will be sealed in 8 years under the Clean Slate Act. He can also reapply for youthful offender adjudication 5 years after his release from incarceration. The sentence, just briefly, was remarkably lenient. As discussed earlier, he faced 15 years for the weapons possession, 15 years for gang assault, and 25 years for rape. And defendant was, while he might have been a 10th grader, he was 18 years old at the time he committed each of these crimes, and 19 when he made his appeal waivers. So he was an adult, and while he may not have had a conviction yet at the time, had certainly appeared in court many times, had been arrested, and arraigned on several counts. So unless there are any questions.
You would agree, even though he is legally an adult at 18, would you agree with counsel's argument that we now know that young people at 18 or 19 are still not fully capable of assessing what they're doing?
Certainly, young people are less able to assess what they're doing, but he was granted every possible benefit of this system. He was given youthful offender treatment for many of his crimes. He was he was released after being arraigned on his gun and rape charges when he committed gang assault, and then still he was given deferred sentencing. So the people believe that he already received every possible benefit of the youthful offender system, and still, again, under the Clean Slate Act and the reapplication for youthful adjudication possibility, we believe that he has received all the benefits that are available.
Thank you.
Thank you.
I'll briefly address the appeal waiver in this case. The appeal waiver in this case was not valid. Suchin had, when he came before the court, he had never been in criminal Supreme Court before. He was a young person that had never prosecuted an appeal before. The court was obligated to explain to him what an appeal was, what that means.
According to the record, the court read aloud the defendant's written waiver for the right to appeal, which the defendant stated he had reviewed with his attorney.
Yes, Your Honor, the court's, notwithstanding that he did say that he reviewed it with his attorney, the court still has the obligation to explain to him what an appeal waiver is. There is no substitute for that. And the appeal waiver, the written appeal waiver, does not in itself explain what an appeal is. And to a layperson, I think that would not be totally clear. For example, the written appeal waiver doesn't say that what he was waiving, what he was purporting to waive, was the possibility of appealing his youthful offender adjudication. And the model colloquy sets out, there's an explanation about what an appeal waiver is. It follows the right to counsel follows it. You file a notice of appeal. You can complain about errors. You complain about your sentence, and that was not done here.
Thank you.
Thank you, Your Honor.
Citibank versus OWS. You may proceed.
Good afternoon, Your Honors. Michael Petrella, Cadwalader for the appellants, and may it please the court. Appellants are here today because the lower court read the phrase "on behalf of Brand Holdings II" out of Section 4.1 of the party's securitization indenture and held that neither Iconics, the manager, or Brand Holdings II, the securitization entity, is responsible for its breach. A breach the lower court effectively held had occurred. And as a result, the appellant note holders, who collectively lent Iconics $300 million, have been deprived of the benefit of the event of default remedies they bargained for to protect their interests. Section 4.1H of the indenture requires the manager, on behalf of Brand Holdings II, to provide quarterly financial statements of Iconics as soon as available. That phrase, the manager on behalf of Brand Holdings II, clearly indicates that Brand Holdings II is responsible for the obligation, and the manager simply acts as its agent in fulfilling.
So you see that clause as unambiguous?
I'm sorry, Your Honor.
You see that clause as unambiguous?
I do see it as unambiguous, Your Honor, and the reason why is because our interpretation, in contrast to the lower court's interpretation, is the only one that honors and gives meaning to every single word in 4.1H and respects the overall structure of the transaction.
How do you explain in that answer, or include in that answer, the fact that the other sections of that same subsections of 4 use different language? I mean, and how does that all play into each other?
I understand, Your Honor.
This was not the model of drafting, I must say.
Hope you didn't do it.
Okay.
I will give you that, Your Honor. Look, the fact is, no one in this courtroom knows why that language doesn't match up, why there's differential language. What I can say with confidence is whatever the parties intended here, they didn't mean for 4.1H to mean nothing, and they didn't intend for it to be unenforceable. And again, I'll make 2 points about this differential language. The first is the drafters of 4.1, I think as you've already figured out, were not particularly interested or attendant to using consistent language. In 4.1 alone, okay, where there's a directive, sometimes the language says shall,
right.
Sometimes it says will.
Will.
Okay? It means the same thing. There's no contention that it means anything
Sometimes it
different.
says furnish, sometimes it says deliver.
That's exactly.
Shall cause, or I mean.
That's right. You're absolutely right. And I think there's another even more important point here on the language of 4.1H. And that is that the language in 4.1H alone, amongst all the subsections of 4.1, accurately states what's actually going on here. And by that I mean Brand Holdings 2 is a special purpose vehicle. It has no employees, it has no operations, it cannot act without the manager. So you can phrase A, B, C, you can phrase it however you want. The reality is 4.1H. 4.1H is how it actually works. The manager acts on behalf of Brand Holdings 2. It's the manager that has to perform those obligations. And that's why I say our interpretation is the only one that gives full respect to all the words in 4.1H. And importantly, our interpretation is the one that recognizes the structure of the transaction. And that is, you've got an indenture here that is clearly designed on its face, and 7.4 is probably the clearest on this. It's clearly designed on its face to contain the obligations of the securitization entities. You've got a separate management agreement that is clearly...
I'm sorry to interrupt you, but I know I'll forget this question. So Judge Baruch said at one point, I don't know if it was an oral argument or whatever, that he thought it was a mistake or a drafting problem, which I guess there was a lot of, that the manager didn't sign the indenture agreement. But would the manager usually sign the indenture agreement, or would there usually be a separate management agreement, separate and apart from the indenture agreement?
I can't necessarily speak to what usually happens, Your Honor, but certainly in this case, there was a separate management agreement signed by the manager, and the manager did not sign the indenture. But how I interpreted what Justice Baruch said at oral argument was, I think as it proceeded, Justice Baruch realized there was something wrong with this interpretation. Something wasn't quite right. And I think by the end of the argument, where he came down was, I think the parties have made an error here in expressing their true intent, right? The parties meant something different from what these words on the page mean, as far as I can tell when I compare these different subsections. Where the court went wrong, and he obviously, that was what he believed, but where he went off the rails, I think, is where he said, there's nothing I can do about this. There's nothing I can do about a Scrivener's error. And I think we've pointed out in our brief, in our case law, that the court can always do something about a Scrivener's error.
What would your reaction, I see your time is up, what would your reaction be if we said, well, you know, this is really ambiguous, and no one should have been granted summary judgment?
Well, I think, in fact, that is one of our arguments.
Better than what you got, right?
It's better than what we got. That's right. That's right, Your Honor. So, yeah, I mean, look, I think that, I think it's true, again, we believe that our interpretation of this clause is the only one that truly works. However, if you put some currency in the lower court's analysis, in their ruling, I think the absolute most you can say is that it is one plausible ruling, right? Or reading, I'm sorry. It's one plausible reading of this contract, and there are others, namely ours.
Right. Okay. All right. Next up. You may proceed and tell us who you're here for.
Good afternoon. May it please the court, Milton Otto, Meister, Sealing, and Fine, for the co-issuer respondents. The decision of the court below should be affirmed in its entirety, and that's because the lower court did exactly what courts are supposed to do when they're confronted with a question of contract interpretation, right? It started with the text of the agreement and the distinction in the text between the manager in Brand Holdings 2.
It's your position that it's the manager who is supposed to do this, right?
Exactly, Your Honor. Yes, that's the subject of the sentence.
So is it commercially reasonable to look at this and say, you've got this indenture, which isn't even signed by the manager, to say that this is the manager who's supposed to do it and not Brand Holdings 2?
Absolutely, Your Honor, and that's because...
So what does on behalf of Brand Holdings mean then?
Well, the phrase on behalf of in this context, and we have to look at the context because you can't just read those words in isolation apart from their context. In this context, it's different from when a party signs an agreement and the signature block of the agreement says on behalf.
Who is it that had the information that would generate these reports that are called for by 4.1H?
The party that has the information is the manager.
Who's actually generating? The manager is filing it, but who's got it? Is it the manager, Iconics Group brand, that's got the information? Because they're the head, the parent company, is that it?
Yes, it's the parent company's information. And that fact, the distinction between the manager, the parent company...
But this is all broken up because you want to protect things from bankruptcy, so that's why you've created these single-purpose entities detaching things.
Exactly. And in fact, the information itself that the manager is providing when it gives these financial statements, that's information about other things that the company is doing outside the securitization. It's their activities all over the world, the information about the stuff that happens inside.
So what you're telling us now is that this information is in the hands of the manager, and it's the manager who's supposed to be furnishing the information. So what's the reason that you have an agreement that says that a manager on behalf of Brand Holdings too? Why isn't it just that the manager shall furnish?
I have several thoughts about that. This isn't just one agreement, right? The indenture is part of an interrelated, overlapping set of agreements. There's a management agreement, there's a servicing agreement, there's a whole set of agreements here that were all executed at the same time.
But isn't there another provision that I think it's in Article 5?
Keep on asking questions. I haven't gotten the answer to the last one.
No.
I want an answer to that question. What does it mean then when you say on behalf of?
So that phrase, Your Honor, it doesn't always mean you're
You
only
said
a
that
common law
before.
agent.
What does it mean here?
It can mean something as simple as for the
What does
benefit
it mean
of,
here?
in place of,
What?
in place of, in lieu of.
Well, why doesn't it say that?
Why doesn't it
then?
say that?
Well,
I mean, it
if, in
seems to
fact,
me
if
that
you
you're
look at
arguing
section
for
4
ambiguity.
I'm sorry?
It seems to me that you're telling us it means something other than what it says, which strikes me as a basis for finding that it's ambiguous. Because if it doesn't say what it actually, if you're claiming it means something other than it actually says, that to me is the definition of ambiguity.
No, I think that I'm arguing the definition of the phrase on behalf of, one of those definitions is just for the benefit of.
So you write that.
No,
Counsel, look.
You didn't draft it either, right?
I understand. I
Okay,
didn't draft
but
the
this
agreement.
is, look, we have what we have, okay? And I have one party saying on behalf of means one thing. I have another party saying it means something else. Sounds to me like there's ambiguity.
So there's a reason that I don't think it's ambiguous. And that's because when you contrast this provision with the other provisions right next to it on the same page, the other sections of 4.1, 4.1a, 4.1c, those are all written differently. They all
And
point
they all
to
say
Brand
on
Holdings
behalf
2.
of.
No.
Almost
Your Honor,
every single one.
4.1a says that Brand Holdings 2 will do the action or cause the manager to do it. What 4.1h says, it's the only one that says the manager will do it. And that's important. And it's not a fact that would have been lost on these drafters because the whole structure of the securitization depends
So
on
if
them
it's coming
being
for the
different.
manager, why are we talking about the Brand Holdings too? Why does this provision talk about Brand Holdings too, if it's the manager?
There are several reasons it could be doing that. And I'm saying we don't get to the parole evidence of why they actually did what they did. I'm speculating now about what the drafter's purpose was.
Precisely. I shouldn't have to consider parole evidence. I should be able to understand it just from the reading. And if I can, then it's ambiguous just as a matter of law.
Well, let me.
That doesn't require a response. It's not a question.
Thank you, Your Honor.
Thank you. Next. Okay, where's he from? Okay, welcome from Massachusetts. We have 100,000 lawyers in New York, but welcome.
Thank you, and thank you for having me, Your Honor. May it please the court, Dan McCauley from Ropes and Gray for the respondent's BOF holdings. Our client is the sole holder of the Class A1 notes that we believe are entitled to the distributions that are at issue in this case. We join the arguments of our co-respondents and
You're not too happy about the change of the waterfall payments in the event there's an event of default here, right?
Exactly, yes. And on that, I think there's two issues that we would urge as
Your
alternate bases
BOF,
for
right?
affirmance. BOF, that's right. And that's the first of them, is the remedy. And I think maybe where I'd start is, there's no dispute that under this securitization, the A1, the more senior note holders, get paid down in full from all distributions that are generated by the securitization. That's the default, right? The remedy that OWS is asking for would turn that on its head. It would turn this into pro rata distributions, and it would redirect tens or hundreds of millions of dollars away from our client. I'd suggest that's a drastic remedy. And I'd suggest that to get that remedy, you'd need a really clear...
But isn't that what it says in the event of default could happen? I mean, that's part of what's in this somewhat poorly drafted agreement.
I think it could happen, subject to several steps down the road that aren't close to happening here. And I'd suggest if it were automatic on an event of default, and while we're all ganging up on the drafters, it would have been really darn easy to write, if there's an event of default, the distributions will be made pro rata, right? There's nothing close to that in this indenture. There's instead, as Your Honor suggests, a provision that says if the trustee exercises certain remedies down the road, and it lists them, right, like seizing and selling collateral, a foreclosure sale, if there's an event of default, and there's a whole sequence of what has to happen, right? Event of default, then a declaration by the trustee that the notes are immediately due and payable. That hasn't happened yet. Then an action to enforce that, for example, with a seizure and sale of collateral. Those recoveries are done, right? That's when everything's gone sideways, and to use my colleague's
You're
phrase,
just
off
at the
rails.
beginning,
We're just
right?
at the beginning.
Just at the beginning.
There's no event of default. And
Well, it hasn't
there's
been
a dis-
decided, I mean.
Yes,
whether
yeah,
there
thank you
is.
for the correction. There's a dispute about whether there's been
Yes,
an
a
event
big
of
dispute,
default.
right.
And an alteration of the waterfall is not the automatic result of that. And that would be a really, really extreme remedy that would require a clear provision. I think the one other thing I'd add is the language, it's 9.3E of the indenture that I think is the provision you're thinking of, Your Honor. It calls for, and I have the language, I should probably pull it up instead of ad-libbing, amounts that are, let me just find 9.3E. Here we go. Amounts that are, quote, obtained by the trustee on account of or as a result of the exercise by the trustee of any right hereunder, right? Those are distributed pro rata. And in that same section, it lists the remedial rights, like the foreclosure sale I mentioned, or the sale of collateral. The right, now, it doesn't, the right that OWS points to that the trustee has exercised isn't a right of the trustee at all. There's a section 5.10 that just says the issuer has to pay collections in the normal course, just like when we all make a payment on our mortgage or make a payment on our credit card, right? Nobody would say that the credit card company or the mortgage company has exercised any rights. The provision, it's 5.10, doesn't even mention the trustee doing anything. It's just the normal course payment of distributions by the company, by the issuers. And so there's no right of the trustee being exercised. There's no amounts that are being obtained by the trustee of exercising any rights under that provision. And the last point I'd make on that, on the remedy, is if it were the case that the normal course payments of collections triggered 9.3E and triggered pro rata distributions, the whole waterfall would be written out of the agreement, because that's what happened all along, right? Like the company collects money, it distributes it into the collections accounts. There would be no priority of distribution, and that's a critical protection for our clients. It's a term that everybody who purchased these notes understood, and the prices that they purchased them at would have reflected those terms. And we'd submit that the appellant is basically asking you to throw those negotiated provisions out.
Thank you.
Thank you. I see my time's up. There's another issue that we've briefed as another basis for appeal about no continuing default, but we'll defer to our papers.
We will look at the papers.
Thank you.
Okay, you have time on rebuttal.
Briefly on the waterfall, Your Honor. 9.3 is entitled Rights of the Control Party and the Trustee upon event of default. So once there's an event of default, what 9.3E says is the waterfall immediately shifts to pari passu. All the Class A note holders are treated on an equal footing, and they're paid pari passu, as opposed to the typical alphanumeric approach. And the reason for that is these kind of securitizations No one lends this kind of money unless they have some assurances that once things start going wrong, okay, we're all going to join arms and we're all going to be treated equally, and we're all going to be treated equally in getting our money back. 9.3e, I think, is absolutely clear on its face. Article 5 basically says there's a collections account. It's in the name of the trustee. The collections money has to go into that account. The trustee exercises its right to those collections funds by receiving those funds into the account. And with respect to hereunder, it's very clear, I think, that it's a reference to the document as a whole, the obligations and the collections and the funds that are received from the document as a whole. The parties, when they intended to limit a reference to a specific subsection, as in, for example, 2.10a, they're very specific and clear. They say limited to this 2.10a. They don't say hereunder. Hereunder means the document as a whole.
Thank you. Thank you all. Trump versus Trump. You may proceed.
Thank you. May it please the court, Ann Champion from Gibson, Dunn & Crutcher for Appellant Mary Trump.
If you want, you could move that mic down a little
good
bit.
idea. Good idea.
That's always my problem when I'm standing up my stuff.
The former president alleges that Ms. Trump breached a confidentiality provision in a settlement agreement that is now more than 23 years old.
But it doesn't have any provision in it about anything in that agreement sunsetting at a particular time, right?
That's correct, Your Honor, but under New York law, if agreements are perpetual, they must state that they are perpetual clearly and unequivocally. And this agreement does not state that.
So since there's no duration set up for this, wouldn't it be proper for the court to hear what the intent of actually entering into this agreement is? And then the courts, sometimes we blue line as opposed to red line, we narrow the duration, we make some changes in it. I mean, we do those in agreements periodically.
Well, I would argue that the case law in which courts have done that in New York is restricted to the restrictive covenant context, which applies oftentimes in post-employment cases.
Yes, that happens a lot in those.
Yes, this is different. This is a settlement agreement. The confidentiality provision is incidental to the settlement, which involved settlement of probate disputes, a separate litigation.
How do we know it's incidental? I mean, how do we know it's not a central part of the settlement agreement? Isn't that something that should develop, that might well develop in discovery? I mean, your client was represented by counsel at the time she signed it. Why would we just throw it out?
Well, the provision actually states that it is there to facilitate the settlement. It actually states that. And it also states that the parties agree that...
That doesn't make it ancillary. It makes, in fact, it makes it sound like it's a critical part of it.
There's no consideration provided for confidentiality, and it's double-facing. The consideration is...
It's all part of one agreement.
That's correct, Your Honor, but it's not a confidentiality agreement. It is a settlement agreement that includes a confidentiality clause to protect the particular information involved in the settlement. And it contains no stated duration. It is therefore terminable at will. Courts have applied that rule with respect to confidentiality agreements, as in Better v. Murdoch.
When you say terminable at will, do you mean that your client could have said 5 days after it was signed, okay, I'm terminating it?
Well, I would say, I don't think the court needs to reach that type of issue. The financial provisions of the agreement were required to be performed within 10 days. They were performed. There's no dispute that they were performed. Ms. Trump had to transfer assets.
You mean it was in effect just for 10 days?
I would agree that it would be reasonable to find the confidentiality provision in effect for 10 days. The agreement does not state it is perpetual, and therefore it is, to the extent it calls for ongoing performance, it is terminable at will. To go to the Ashland line of cases, In such cases, courts have sometimes inferred reasonable time limits, but I would submit that no discovery is necessary even if the court were to conduct that type of inquiry. Mr. Trump didn't put anything into the record justifying this agreement lasting for this long. And courts in this state have thrown out agreements as short as 3 years for being too long. The types of durations that are approved in that context are in the order of 18 months, a year. They nowhere near the 23 years that would be needed to apply here. And again, Mr. Trump had an opportunity to put in evidence of this nature, and he put in nothing. There's no reason that discovery could possibly show that this agreement could last for this long, especially given the drastic change in circumstances between 2001, when this agreement was entered into, and Mr. Trump deciding to run for office in 2016. Moreover, if the agreement says what he says it means, he breached it. He gave an interview to the New York Times in 2016 before any of the conduct that he alleges constitutes breach here, in which he talked about the will disputes. He told the Times that he retaliated against Ms. Trump and her brother after they objected to their grandfather's will by cutting off their medical benefits. He told the Times that he was angry because they sued. He told the Times that Ms. Trump and her brother were excluded from their grandfather's will due to his tremendous dislike of their mother. He told the Times that the litigations had been settled amicably and that he was very fond of Fred III, Ms. Trump's brother. The agreement provides no basis on which to distinguish the statements that he made to the Times from the statements that Ms. Trump made. And because he breached first, he's in no position to enforce this agreement. In addition, the agreement, he has pleaded no damages. As this court knows, you cannot recover reputational damages for breach of contract. Mr. Trump in his complaint states no basis of harm. He identifies no facts that would support any harm stemming from the alleged breach of this agreement, and that is another basis on which this claim should be dismissed and should have been dismissed. For example, the court in Gordon v. Dino De Laurentiis Corp., that was the First Department case, 141 AD 2D 435, dismissed a claim for breach of a confidentiality clause because the complaint did not demonstrate how the defendant's alleged breach caused plaintiff any injury.
Well, haven't we had cases from our court that say even if the plaintiff has not alleged damages that you feel are recoverable, like reputational damages, nominal damages may still be available even in the absence of actual damages? We've written cases that say that.
He didn't plead nominal damages or exemplary damages, and those types of damages are not available if there is not some basis for actual damages. They are used sometimes as a substitute if it's hard to calculate, but they are not available if there's not actual damage.
If you make a contract, the very purpose of which is to protect reputation, is it not possible to recover damages for damage? Is it not possible to recover for damage to reputation as a result of the breach of that contract?
Again, I don't know that we need to say it's never possible. It's definitely not possible here because...
I know you cite the Dan Rather case on the reputational point, but it's not a case that's really similar to this because there was provisions that he was to be paid, and if they didn't live up to the contract, then he should have been paid off the rest of his salary right away. So it's not really a matter of reputation there. But if the very purpose of the contract is to protect reputation, is it not possible to collect damages for reputation if you breach that contract?
Again, I don't think there's an argument here that the purpose of this was to protect reputation. It talks about protecting the particular details of the settlement. But setting that aside, under New York law, if a claim is one seeking reputational damages, it is a defamation claim. A defamation claim would be barred here for two reasons. It would be barred by the statute of limitations. This complaint was filed more than a year after the book was published. In addition, it would be barred because he has not alleged that anything in the book or the New York Times articles was false. So there is no defamation claim. He cannot recover for reputational damages. And by the way, he has not claimed any reputational damages. It's just the only conceivable basis he could have.
Thank you. You'll have time on rebuttal.
Thank you.
Good afternoon.
Good afternoon.
Alina Haba, I represent the respondent in this matter. There are a lot of things that I can rebut there, but generally speaking,
As to the duration of the agreement for confidentiality, so I noticed the references to the fact that the appellant, when approached by a reporter, said, "I can't talk to you," which I think happened in 2015 or something. Is that an indication that the appellant regarded herself as bound by this confidentiality provision?
I think that he made a point, and frankly, we have a case, Ashland case, which speaks to this. The duration argument that counsel made is not relevant here because the First Department, our court, has actually held that durational limits are not required for confidentiality agreements. And yes, I do think that the respondent in this case made a point of not speaking about what was at issue here, and I think that's the point. This is a breach of contract claim. I agree with counsel. This is not a defamation case. There was a contract made, there was consideration given for that contract, and she willfully, wantonly breached it, stated that she knew the terms of that agreement, she knew that she was breaching it, and disregarded that.
She said something today. Counsel said something earlier today, I thought, during her argument, that your client breached the confidentiality agreement, so therefore she could breach it. Like, was it an anticipatory breach? Did it take away her obligations? If you could speak to that.
Sure, Your Honor. None of the statements that they referenced are related to the estate actions, except when he said it was amicably settled, which is absolutely permissible. This broad
So if he said statements that related to why the brother was disinherited, that has nothing to do with the settlement?
That had nothing to do with the terms of the settlement, Your Honor.
Really?
The settlement, the estate planning issue, which is what this was, a contract was.
Yes, but it was a settlement about what part of the inheritance, if any, Fred and his heirs would keep, correct?
Your Honor, even if that's
is that correct?
Yes, he spoke to the inheritance, but that is not to what the settlement was regarding. And even if that is Your Honor's position, I would say that the court must look at the gravity of what she did. And at this juncture, with a motion to dismiss, we haven't even gotten discovery to know. We know she gave tens of thousands of documents that were part of the estate action. That was part of the confidentiality agreement. We don't know to what extent on that. Additionally, she actually went on Stephanopoulos, and just to give you a comparison, there is no comparison. She said, there are a few reasons I didn't feel...
All right, so if there was a breach on the part of your client, you're saying that the courts have to then engage in a weighing of whose violation was worse? Is that what you're suggesting?
Well, Judge Reed correctly observed that whether President Trump reached his obligations is one fact at this stage, and there's certainly at this juncture is a question of fact. And we're here to decide whether Justice Reed was correct, and I believe he was. This is not the position. She can file a motion for summary judgment and has that available to her after discovery. So that really is, and you know, moving on, Your Honor, if I answered your question.
Go ahead.
Counsel,
Yep.
where does your client show any actual damages in his complaint? I don't see it.
Your Honor, again, this goes to a couple things. Number one, we do mention that she gained intentionally profits by violating this, and that by doing so, this has nothing to do with defamation. This has to do with the fact that he has available
He's
remedies.
entitled to whatever she earned?
Well, there is disgorgement argument for the fact that she made money off of going after, basically breaching this
And
contract.
that should then
That's
go to
one thing.
him? Under what theory?
I'm sorry, Your Honor.
And what is the theory under which that profit should go to him?
Well, number one, there is the first theory, which is that she breached a confidentiality agreement solely for the purpose of making money, something she said herself. She, regardless, in our complaint, there are actual and compensatory damages claimed that were caused by her.
I don't see where you allege any compensatory damage.
We said there was dissemination of proprietary information.
But how did that cause him any damage?
Well, I mean, I could go into it, but that was part of why the New York Times was part of this case. New York Times, the anti-SLAPP was properly applied there. I didn't appeal that decision. The law did change. It's a new law that's being interpreted. And actually, from the minute I filed the complaint until we heard that, Judge Reed said, well, now the law has changed and it's continuously evolving in New York, as we know. Here, I don't believe anti-SLAPP should apply to her in this circumstance. I think she's trying to hide behind a contractual basis, and that would cause a tremendous public policy concern for the state of New York. We're just not supposed to
I
do
asked
it.
you about damages, not about public policy.
Well, I do think we're entitled under restitutionary damages under opportunistic breach theory.
Restitution means you lost something. So again, what are the damages?
Well,
restitution means I lost something out of my pocket. You got to put it back in my pocket. So what did he lose out of his pocket?
well, first on its face, we know that she gave thousands of documents to the New York Times, and then they filed a massive article that was effectively a hit piece, as you would call it, against President Trump in a campaign.
Again, how does that translate into damages, actual damages?
When you breach a contract and you pay for that contract, you should get the restitution of having that money paid back. If somebody breaches a contract, he paid millions of
I
dollars.
don't think you
for her.
understand restitution then, because that's not restitution.
To be honest, Your Honor, at this juncture, I don't know what was given. This is the whole point. I don't think it's ripe for a motion to dismiss because I can't fully answer that question. We have had no discovery. We don't know what she gave out. We do know some of it was personal returns, financial information of the family, including President Trump. But without discovery, I can't fully answer that question, which is why I think at this juncture, we should affirm, frankly, Judge Reed. It's too early to tell.
Thank you.
Thank you.
Just a few brief points. The settlement agreement was not just about the will dispute. It was also about a secondary case that Ms. Trump and her brother and his family filed over the termination of their insurance benefits. It was also about
their health benefits.
Correct. And it was also about Ms. Trump and her brother had inherited directly from their father, when he died, interest in the Trump family business. So the settlement agreement also covered their transfer of those assets to the rest of the family. It was the buyout of their interest. So it's broader than just the will case. And I think that's important because, again, if we go back to the statements he made to the New York Times, he talked about the will dispute, he talked about the health insurance dispute, he talked about why they were disinherited. In other words, his comments are not limited in some way. Moreover, the
but the fact that we're dealing with a motion to dismiss, and it's early on in the case, I mean, we have the fact that in a July 2020 interview, your client says, I didn't feel that the NDA mattered one way or the other. So there's an indication, at least there's some indication in the record that as of July 2020, your client still felt that she was bound by the NDA.
I would dispute that, Your Honor. She deferred to her lawyers. If you read her full statement there, she said I'm not a lawyer. There are technical reasons. But she also has submitted an affidavit.
This isn't whether I had to publish this book on my own or suffer the consequences of a court battle. I didn't care.
Well, I will say this. She believed the family would sue because it's so common. And Robert Trump did sue before her book was published. So I think that's a separate issue of whether she believes she breached. She submitted a sworn affidavit in which she said she never thought that the agreement could cover the disclosures she made in her book. Just a couple brief points, if the court will indulge me. So
I'm going to give you 45 seconds. Okay?
I just want the court to focus on the language of this confidentiality provision because it provides no basis to distinguish between the statements the former president made and what Ms. Trump is alleged to have made. It provides no basis. And the Supreme Court of Citizens United has said that part of the reason that courts cannot enforce agreements, vague agreements of this nature, is that the interpretive process itself raises serious First Amendment concerns. I don't think the agreement provides any basis to draw lines between her statements and his, nor does it enable the court to do so in a way that would possibly be consistent with the First Amendment. Thank you very much.
Thank you. Renard versus New York City Board of Elections.
Good afternoon. Good afternoon, Judge Gesmer. We used to be neighbors. I think our argument...
We're still in court here. You may proceed.
Our argument here is pretty simple. First, I have to take this off. The amendment, the CPLR 2106, as it is stated, actually has a section, as I go through this, each time I find something more, has a section A, which is about what an attorney or a physician, osteopath, or dentist has to say in an affirmation.
That was in the old version. That's not in the new version. That's not in the current version.
Yes, 2106A, and then 2106B has 2106A says affirmation of truth of a statement, and then B says the statement of any person when that person is physically located outside of the.
That's
But
the
isn't
old.
part of
That's
what
the
you're
old
reading the
Right,
old
that I'm going to go on
statute?
to. The legislative language, sorry, I took that from whatever version of McKinney's came up in Westlaw. The analysis that was done by Judge Rios in Queens County, I think, holds very true. That the purpose of the amendment was to bring New York courts into line with the way we practice in federal court or in other states, which is that.
May be true, but it also had a specific provision saying that any person who wanted to affirm something had to use specific language, which doesn't, I affirm this blank day of, under the penalties of perjury, under the laws of New York, which may include a fine or imprisonment, that the foregoing is true. And I understand that this document may be filed in an action or proceeding in a court of law. And
But Judge,
that's very clear, and you didn't include that language.
As I said, I put in the record, there wasn't a single election law verification in this.
It doesn't matter. The question is, what we have to decide here is whether your verification is in line with the new statute as it reads.
And if the new statute was intended not to change what attorneys had to do, or whether what I said was substantially in compliance, which
The
could
statute
be.
says what it says. And I mean, if your position is you didn't have to follow it because other lawyers didn't follow it, are you suggesting that when 3 people jump over a turnstile and the 4th one does too, they can say, oh, I thought everyone could jump over a turnstile? I'm having trouble understanding why lawyers should be able to not follow a new law, which is pretty simple.
If every lawyer in this state who does any kind of, I would chance to say that you will not find a single lawyer who's used that format except.
Perhaps, and they would all be wrong.
But if the legislative history says that the purpose of this amendment was to allow lay people, not lawyers, to verify.
The problem is that I am stuck, and this court is stuck, and the court below was stuck with the language that the legislature gave us. We don't have the right, the ability, the power to say that's not what they meant. What they really meant was this. We don't have that power. We are stuck with the language we have.
You do have the power to say that what was the
So
attorneys.
tell me why your language of, I believe what you said was, under the penalties of perjury, that's it. You left out all the other language, why that is in substantial compliance with the new language.
Because I'm an attorney, admitted to the bar of the state of New York, that's what it says, swears under penalty of perjury as follows. And the statute still says doesn't say it says has to substantially be in the following form.
I mean, I understand where your argument could be coming from, but, and I understand what this sponsor memo said, but the actual statute actually specifically crossed out the
Words.
the provision that dealt with attorneys specifically, and now they say anybody anywhere has to do this. So it maybe the language of the statute is not exactly in compliance with the sponsor's memo, but we can't exactly fix that up. That may have to be fixed up in Albany. But in any event, that's the problem
But
that
you
we're
can
having.
find that the statement by an attorney under penalty of perjury is substantially in compliance.
How can we find that when the law says
That's a matter of-
specifically
that's a
what it
matter
should
of opinion.
say? It doesn't say which, I mean, your statement did not say which may include a fine or imprisonment, and it doesn't say, and I understand this document may be filed in an action or proceeding in a court of law. Maybe you think every lawyer would mean that, but I don't know that. And that's
Your
why
Honor,
this is very, and it doesn't say, and lawyers don't have to say substantially what this says. It says everybody has to do it.
If this court rules that way, there's going to be a lot of Article 78s that get thrown out and can't be repled because nobody uses that language. No, but I don't think that was the intent of the legislature. It may be exactly what was said.
You may be right. And I suspect if you are right, that the legislature will, in quick order, I hope, fix it. It says what it says.
We don't know.
Okay, thank you. I will hear from you now.
Good afternoon, may it please the court. Paul D. Newell for Respondent Hutchison.
Let me play devil's advocate. Most lawyers, I would say any admitted lawyer in the state of New York should know that that anything they say is subject to not just the penalties of perjury, but also the laws of New York State. Why is that not an obvious thing for an attorney who's licensed in this state?
Well, it might be depending on the context, but here the legislature, in no uncertain terms, laid out the requirements of an affirmation made by any person wherever made, and precisely and deliberately struck out the distinguishing language between attorneys, certain medical professionals.
Can
and
we
other people.
agree that the purpose of this statute was in order to make it easier for lay people in this process to participate, to be able to file papers without the need of having notaries, et cetera, so that these issues, which we can all admit are very fast, time-paced in terms of time requirements, right? In light of that purpose for the statute, should we interpret it so strictly as against lawyers for whom it was not intended?
Well, I don't think we know that it was not intended to be for lawyers. I would agree that liberalizing pleading and making it possible for lay people to affirm does seem to be one of the intents. Also, to make it easier for people within the United States to affirm, but quite clearly, this is a
statute eliminated the distinction between lawyers and lay people for this purpose.
Exactly, and that may in fact also have been one of the intents of the legislature. It certainly appears to be, since they specifically struck through that distinction in the bill, which was, the bill was attached. I'd also like to appellant relies on CPLR 3021's governance of verifications of affidavits of verifications. These two sections are not at all in contradiction with each other. They can easily continue to be read together. CPLR 3021 refers to what the affiant must affirm, namely the basis of their knowledge or belief, and CPLR 2106 states the form of that affirmation and the gravity, and requires language showing the person affirming knows the gravity of their statement, that it is not just under penalty of perjury, which is just a term, but it could be that could involve a fine, imprisonment, and that this will be filed in a court. This goes to the very core of all affirmations, including verification.
All of those things are things that attorneys know. don't they? I mean, any licensed attorney
Certainly
worth their salt would know that, no?
Well, again, it would depend on the context.
What context would a lawyer not know that an affidavit could be filed in court? On what context is that not known to a lawyer?
People file. I've been in.
That it can be, not that it is going to be, that it can be. Every lawyer knows that, right?
Well, I do think there's varying contexts.
It's okay for you to say yes. It really is. I mean, I understand you want to say no, but sometimes there are certain points that you can concede without dropping the ball, okay? And I don't think you dropped the ball by saying that an attorney knows an affidavit can be put into a court.
Well,
Right?
let me say that regardless, the attorney must comply with the statute.
Okay.
Pertaining to affirmations.
Fair.
Perhaps because I've only been admitted for a couple of years, I'm more inclined to look things up before filing them, and I suspect if there is a decision from this department, from this court, requiring this verification, folks will change their practices going forward. At least they should. But there is no question that the statute clearly requires the language.
Okay, thank you.
Thank you, Your Honors.
Thank you so much. Last but not least, GSB Gold versus Google. You may proceed. Thank you.
Recognizing the colloquy from earlier.
Yes.
May it please the court, my name is Paul Allen Levy, appearing this afternoon for the anonymous blogger behind MLM. The main issue in this case is what legal standards should govern GSB's subpoena to identify the author of several critical blog posts in light of her First Amendment right to speak anonymously. And we urge the court to follow the lead of the appellate courts of 11 states and several federal courts to require a plaintiff in such or a would-be plaintiff in such cases to make a showing of evidentiary merit before identifying anonymous speakers whom the plaintiff wishes to sue. A majority of those courts also require a balancing of the interest as the final stage. And in that regard, I concede that anonymity that the internet affords can be abused, and we do not argue for any absolute right of anonymity. But there are other cases where the plaintiff seems to be interested a little more than unmasking, and where the mere filing of the case has a chilling effect. So the standard must not be one that unduly encourages such subpoenas. The chilling effect of a rule that makes identification too easy risks depriving the marketplace of ideas.
In your view, what would need to be shown in order to be entitled to disclosure?
I think you would, in a defamation case, you identify the allegedly defamatory words. You have an affidavit that explains the way in which they are false, and you would probably need a brief which talks about the words in context to make sure that you're not just looking at isolated words, the way this court, in fact, said in the Sandals v. Google case, in which the First Amendment standard wasn't discussed, but that's the way the court analyzed the way in which anonymous posts should be adjudicated to determine whether they're fact or opinion. So because of these
Counsel, isn't your much easier argument that your client wasn't given notice either of the proceedings in Germany or of the proceedings here?
Well, yes, although once that might have been a defect of the petition, but the orders were entered after our client knew and moved to quash. Certainly the requirement of notice is an important one, and the fact that no effort was made to give notice until after the subpoenas to Google were were approved by the court is an interesting factor, which we think goes to the balancing stage. But the fact, it is not only that our client was not given notice of the German proceedings, our client was not involved in the German proceedings. And the German proceedings, if you look at pages 17 and 23 of the record, the German court said, we assume these allegations to be true only because Google didn't contest them. So that alone is a reason, in our view, to reverse and remand and let the district court, let the Supreme Court sort out based on any further allegations they might want to make. They might want to make an allegation of actual malice, since I think they're plainly a public figure. They might want to explain the words in context. In fact, if you look at the verified petition, which cites in footnote 2 the blog post on which some of these words are alleged to appear, they don't appear in that blog post. Now, they do appear in other posts on the blog. I think a better presentation in the Supreme Court by their side, and of course, we'll be making our arguments on our side, but I think you should adopt the standard that we propose, say that the trial court's analysis based solely on the German orders is insufficient and remand for further proceedings. I'm certainly prepared to argue how this court might address the merits if it wants to go beyond that and talk about whether these snippets have been taken out of context and so forth. But I think the easiest way to dispose of this case is to reverse and remand and let further proceedings take place.
Thank you.
Good afternoon, Your Honors. Daniel Podasky for the respondent. Simply put, there is no reason to alter the trial court's discretionary determination here, denying the appellant's motion to quash.
Counsel, the trial court gave essentially preclusive value to the decision of the German court, even though that was entered on default, even though petitioner was not a party to that proceeding and was not given notice of it in any way. So isn't that the error of granting that decision preclusive effect enough reason for us to reverse and remand?
Especially since the court saying that Google had not, the German court's decision was based on Google not contesting it, the veracity of what was said or not said or posted. There's no way that Google could have. They weren't the content creator. So that without having this person reached, right? They didn't have all the facts. The court couldn't have considered whether it was appropriate or not.
I think for the reason that we're here today, there was a petition, there was a separate motion, there was a separate record that was created and presented to the trial court here that established that GSB has a meritorious claim for defamation. That was separate than the record that was presented for the motion to quash the subpoenas. And as to the question about—
But that decision depended in large part on the German court's decision.
Yeah.
Well, it relied on the German court.
Right, but that's the point of my question, which is, how can you justify the fact that the court gave the German court's decision preclusive effect when the petitioner was not a party to that?
Well, and how do we name them as a party? We don't know who they are. They hide behind an anonymous shield, so I don't know.
Well, her papers say that she's actually quite reachable by her, through her email, through her website.
But the proceedings went forward in Germany, okay, and we don't have an individual. We don't know we have a website.
Counsel, there was no attempt to contact this person, to email her.
Who is
her or him? I don't know if it's a her.
They. We can call them they.
Right, they. So this behind MLM, right? Whoever the author is, they go by the pseudonym of Oz. Let's call this individual Oz, right?
Who is them? Who do I go after? If they went to Germany, who do they go after? There's a website.
The website has an email, right?
Okay.
Did anyone send an email to us?
This was not an
Did
argument.
anyone send an email to us?
This was not raised. with-
Counsel, I ask you a question and you talk about something else.
okay.
Did anyone send us an email
I don't have.
before proceeding in the German court?
I can't answer that question because I don't have the record from the German court before me as part of this record, okay? It was not brought up when the petition was filed, okay? There was an order from a German
And
court.
yet we should affirm a decision based on a German court that you can't even answer questions about. And which means that the court below couldn't answer those questions either.
The court reviewed the German court decision and exercised its discretion and said, this
Did
court
the
has-
court have the evidence that was put before the German court or just the German court's decision?
that is a part of whatever was part of the record for the petition
Can I
filing.
get a straight answer? Did the court have the record that the German court had in making its decision? It's a simple question.
Okay, the reason we're here, the answer is I don't know, because the record that's here and what we're deciding is not the same record that was presented to the trial court when it granted the petition. It's a separate record, and it's
Counsel, the trial court writes in her decision, the record shows that a court has already determined the statements made are defamatory per se, thus they are not subject to protection and anonymity under the First Amendment. Second page of her decision,
yes, Judge.
based on the German orders.
Okay, but what was presented to the trial court by the appellant here was an argument that the subpoenas should be quashed because New Jersey law requires a New York court to assess First Amendment rights after there has been a finding of defamatory conduct. And that is not the standard. So the question is what was presented to the trial court in the record? Should it be affirmed? And I think the record that's here, and based on the record that was before the trial court, it was a sound exercise of the trial court's discretion to deny the motion to quash. And I thank you for your time.
Thank you. You have a minute? It's a long time before dinner, but I thank you. Have a good evening, all of you, and enjoy your respective dinners. No hugs today?
We all stumble over our words sometimes. I don't want to stand between you and dinner either.